33 of today's list, my lords. Lordship, I am appearing for respondent number 9 in this matter. Lordship, we were supposed to file an affidavit. Lordship, I seek 10 days time. We'll file an affidavit within, and the matter may be posted after 10 days, my lords. I've informed the other side, my lords.
The A. Solia, the learned counsel, appearing on behalf of the
Respondent number 9, Lordship.
respondent number 9, seeks for an accommodation for filing the affidavit without fail. This is the matter on 29th of September 2023. The affidavit we filed by 25th of September.
Lordship, for listing a place in motion matter, which was mentioned yesterday, for today, but only one effective case was not dated yesterday. But case is dated now, and my matter is relating 3,000 giga of patta land, which are patta documents in our hand from 1929 onwards till 2016. Revenue also paid to the government.
You want to do it today?
Today, fine. In respect of item number 54 and 55, my lord, there are two minor typographical errors. If I may be allowed,
50?
54 and 55, my lord, supplementary.
You want to upgrade it?
No, lord, some correction needs. My typographical error, lord, so I may be allowed to correct it.
Please,
Praise the Lord. I beg to mention item number 32. I have taken the consent of the other side. The wife of the senior counsel, Mr. Deka, was hospitalized yesterday, so he's unable to come before this honorable court to argue the matter.
You are appearing for
Petitioner.
the request of the learned counsel for a petitioner matter stands adjourned for 6 weeks.
may I please, your lordship, I beg to mention item number 10 for adjournment. My senior, Mr. Mukesh Sharma, is not well. May I kindly adjourn the matter for the day. Item number 10.
What happened?
He is suffering from a physical illness.
What is this physical illness business?
It's a fever, cough. I am for
At the request of the learned counsel for the petitioner, had to be listed after 2 weeks.
much obliged.
May I please?
My lord, I beg to upgrade the item number 58, my lord. This is relating to the custom seizure of vehicle, my lord. Last occasion, your lordship was pleased to heard.
Okay, let's see.
Let us
We'll try our luck at 2.
item 45 is this. Some urgency is there, but
Item
45.
45, what is it?
But pendency of the civil suit matter, the municipal court has issued another notice matter, stopping my construction, whereas matter is pending before the court below matter.
So,
And
get an injunction there.
injunction already been executed, but since the matter is pending before the court itself matter, on the same subject matter, they have again issued the notice, and our high court also said that pendency of the case matter, this notification cannot be.
Mr. Chetri, better if the matter does not reach. Because if it reaches, it will have a very bad fate. So let the matter remain as it is. Don't upgrade it. We'll see when the matter is called.
May I please, lordship? Lordship may not like to take up item number 48 of the daily list.
No, not before me.
Yes, my lord.
Your lordship, I would like to mention item number 5, your lordship.
5?
Item number 5, your lordship.
5.
5. Your
Yeah.
lordship, we have filed the additional affidavit today to bring on record some of the medical documents. So
Hmm?
we have filed an additional affidavit today, your lordship, to bring on record some of the medical documents on the petitioner. So it may be taken off the next week, your lordship.
You want the,
Matter to be taken off the next week because we have filed an additional affidavit today, your lordship.
so you want an adjournment? Or you want that affidavit be brought on record?
We have got on record and take it up on the next week,
When do you want?
next week, any day.
At the request of the learned counsel for the petitioner, the matter stands adjourned for a week.
Highly obliged.
Yes,
Please,
madam.
your lordship.
Lordship, in this matter, the petitioner sought for an permission from this court for to go for an IVF treatment, Lordship, as because the husband already crossed the bar limit of 55 years, Lordship. The matter is urgent, Lordship, pleadings complete in next date, any date, Lordship. Last listed on.
You want it
25th
for orders or admission?
admission.
What's
Last
the
listed
matter again? Which year?
2023 matter, Lordship. 23 matter, Lordship.
Okay, list the matter on that 18th,
Lordship.
18th September.
May I please, Lord? You have taken mention item number 46, Lord. But I may be allowed to withdraw this petition.
Your name?
PJ Dutta.
Mr. PJ Dr. The learned counsel appearing on behalf of the petitioner submits that he has instructions for withdrawal of the writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Apply.
Thank you, Lordship. My lord, eviction matter, my lord, we have filed, my lord, yesterday, Lordship. My lord, tomorrow is the, my lord, cut of date, Lordship, for to remove my house from my own personal land, Lordship. My lord, may I pay for two less, two, Lordship, very urgency.
You want to do it today?
My lord,
You want to do it today?
my lord, I pay. before-
Tomorrow I have this court is not sitting.
My lord,
You want to do it today?
yes, Lordship.
Today?
My lord, 6 cases, Lordship. My lord, 6 cases, Lordship. Sam, my lord, Lordship, similar, Lordship. All right.
Motion?
Motion, Lordship.
May I please, your Lordship? Lordship, in regard to item number 59 of the supply list, my lord, 59 of the supply list, my lord. We filed on affidavit yesterday, my lord, to bring on record the service of notice upon the respondent number 4 and 5, my lord. So that may be a call from my lord, place it on record. That's
Okay.
it.
May I
Of
please,
life.
Lord? I beg to mention for listing of a writ petition for Monday, my.
Why?
There's an urgency, my lord, the bank illegally NPA our account, NPA the account. There is an urgency.
We'll have it on Wednesday,
Kindly, my lord, Monday. There is.
Monday?
Yes.
Monday too difficult. Wednesday.
Please, your Lordship, I beg to pray before listing this matter, as the matter is pending since 2021, Lordship.
Hmm?
Matter is pending since last 2021, Lordship.
So what is the urgency?
Lordship, the matter pertains to non-payment of contractual bill, Lordship.
Oh. Try your luck with the registry. Get it listed. Because you need to only try your luck there. Once that luck is there, the matter comes before this court, the matter will be disposed. So you have to try your luck with that. Next.
Like to mention for listing a WPC of 2020. Actually, we are holding the lands under the lottery system, and now the municipality wants to acquire our land. So this matter was last posted on 18/12/2020. Your Lord. Kindly fix it on 11/9.
You got a stay order?
No, Your Lord.
Then
Uh,
what is the
sorry, Your Lord,
urgency?
We had a stay order. Your Lord.
So you should be happy. You have a stay order.
Your Lordship, the matter not been heard since 2020.
We'll have it on 25th of September.
25th. Whatever.
May I please, your Lord? I beg to mention item number 38, my lord. The English council, item number 38,
16,
38.
38.
The
Yes.
English council, Mr. LK for the petitioner has been hospitalized, my lord, day before yesterday and is going under medical treatment. Matter is adjourned for today.
At the request of the learned counsel for the petitioner, matter stands adjourned for how much?
4 weeks.
4 weeks.
No, right.
Supplemental is item 52 for withdrawal.
May I please, your Lordship? Lordship, the petitioners are ward commissioners of Abhyapuri Municipal Board, and they wanted to vote for a no confidence motion against respondent number 5 and 6. They wanted to vote for a no confidence motion against respondent number 5 and 6. But some of the requisitionists have withdrawn their request, and hence the matter has become infructuous.
The learned counsel appearing on behalf of the petitioner submits on instructions that the writ petition has become infructuous. And as such, the petitioner would not like to the cause of action for which the writ petition was filed has already become infructuous. And as such, the petitioner would not like to press the instant writ petition. Accordingly, the writ petition stands closed as it has been on withdrawal.
Obliged.
Interim order, if any, stands vacant.
Item number 1 for motion.
Yes.
The last order of this honorable court, Lord Chief.
So what is your grievance? What is your grievance?
Well, the grievance is that the lordship, we have filed an application. for
That he had
request-
purchased through a registered deed of sale dated so and so. So what is it? To grant mutation on the land of the petitioner within a specific time.
Application for.
Where is the mutation case filed?
My lord, that is case, your lordship will file case 22.
Page
22.
22.
This case was registered as GM case number 19/19/20.
This was filed when? Number 2019-20.
My lord. My lord, if your lordship kindly come, why they have lordship dealing the process, that is case 20.
Why the mutation has not been granted?
The case 28 lordship.
Page 28. The applicant is in the case is taken up upon the notice is duly served that the notice. Yes, then
Now your lordship may kindly come to page 31.
Hmm.
They have wrote to the, written to the secretary to the government of Assam.
then
And lordship, government of Assam lordship written to the deputy commissioner, that is page 42.
where?
Page 42 lordship.
Yes, then
Thereafter, lordship, various levels of report was collected from the circle officer, page 43 also.
what land did you purchase?
My lord, that is a patta land, patta land,
Is
lordship.
it Patta land?
My lord, patta land.
Show me your sale deed.
My lord, sold it page 12.
Why it is being mentioned then that it's a FS grant?
My lord, that is the government has lordship.
Yes, who is appearing for the government? What is your instruction? Because on the last occasion, 2 weeks' time was granted to the government advocate.
Yes,
for
my lord.
bringing
Last
instruction.
evening we received instruction, but after going through it, my lord, I find it's not up to the mark, my lord. The query.
Not
raised
up
by
to the mark.
No, no.
Okay.
So I,
Now, Mr. Barbujari, what is this? The land which has been purchased happens to be a land pertaining to KP Patta number so and so.
No, that is true, my lord, because my lord is aware, my lord, in that Kharguli area, although it is a Myadipatta classified land, but the, my lord, revenue records still, my lord, maintain the nomenclature as FS grant. Now, FS grant originally, my lord, those lands were allotted and settled, my lord, for the purpose of tea cultivation in that Kharguli area. Therefore, my lord, there at one point of time, my lord, in the year 2002, the government of Assam in the revenue department issued certain notifications, my lord, thereby requiring for alienation of any land, my lord, with regard to where, my lord, tea cultivation or special cultivation is going on, then, my lord, the approval of the government has to be taken. Now, here, my lord, the deputy commissioner has written to the government. Now, the government, my lord, at page 42 has, in the repetition, has returned the proposal. But what I find here, my lord, from the record, my lord, that there is no cultivation of tea as such in the
land in question.
No, first of all, how did the name of the vendor's name was inserted? Tell me,
My lord,
how was the vendor's name inserted?
the vendor, my lord, perhaps vendor has purchased it from some other person.
Absolutely.
Yes,
All these lands belong to this family of Manik Chaudhary.
yes,
So then,
yes. Otherwise.
and it is in his name. He has been selling all along all other
Yes,
properties.
yes,
Then why you are not granting on unnecessarily? When his vendor had his mutation,
yes.
and now what is all these things?
Otherwise also as on date, my lord.
And you are and the granting of a mutation is only for the purpose of revenue.
No, it is for the purpose of.
Then what is all this thing?
No, but there is a my lord circular way back in the year 2002 that lordship will find a mention at page 42. Perhaps the authorities.
You are mentioning about that sale of a tea garden.
Tea garden.
That is by the CK Das.
CK Das, yes.
Yes, I remember that. I had dealt with in that other matter.
Yes, that is my lord
Yeah.
government circular dated 16/8/2002. Now, my lord, after redesignation of all the deputy commissioners as district commissioners, they have been given the absolute authority, my lord, to take a call. Lordship may direct the deputy commissioner, my lord, within a time frame. They will meet it. Otherwise, my lord, save and accept only for the reason that if it is a special cultivable area land, then only the approval of government is to be taken. Save and
No,
accept,
that document, that communication of Mr. Siketa
my lord.
to the deputy commissioners was to the effect that there are certain sale of tea garden lands or alienation, so kindly don't do it without the permission of the government,
Correct.
and any mutation should not be done. Now this land is no longer a
Yes.
tea garden land,
So therefore, my lord, it had
and
their-
everybody, apart from that,
Yes.
the petitioners, what you call the vendor,
Yes.
his name was duly inserted. Do you have the case records of that?
Yes.
You have given the permission here.
Yes,
See, the permission has been given by the deputy commissioner. Kindly see annexure 2.
It is there, it is there, everything is there, my lord.
Yeah.
Plus, even my lord, in the circle officer report, lordship may kindly come to page 49. This will give a handle to the court, my lord.
Eight.
Page 49 of the writ petition, page 49. So this is a report from the circle officer.
Hmm.
Down below the report of Lat Mandal is a land is free from schedule T. It should be T, my lord, wrongly.
It is tribe land.
My lord, page 50 is the
It is free from, actually doesn't fall within the chapter 10.
chapter 10. My lord, no, if page 50 is the vernacular, I am reading the vernacular, my lord. Usoriya Zami, জনজাতীয় বেষ্টনী বাহিৰৰ জমি হয়। উক্ত জমিত আবেদনকাৰীয়ে RCC ঘৰ সাজি পৰিয়াল সহ বসবাস কৰি আছে। That means there is no special cultivation of tea in that land in question.
No, you see, forget about all other things. Kindly
madam.
see, kindly come to page 17.
Yes.
See the permission which has been granted by the deputy commissioner.
Yes.
It has been given only, not even for agricultural, it has been given for residential.
No, that is my lord one aspect. The deputy commissioner gives permission, but here since the bottleneck is with regard to whether if it is a tea cultivable area, then approval. Now from the circle officer's report, lordship has seen that there is no special tea cultivation. So that 2002 circular perhaps will not apply here. Lordship will dispose it, directing the deputy commissioner. Because otherwise, this is my lord.
Where is that communication? 2002. Actually, it's not 2002, that is 2001.
Page 42.
Huh?
Page 42.
Page 40.
Page 42, there is a reference at paragraph 3, my lord.
Page 42.
My lord. Page 42 of the writ petition.
Reference to where?
Last, serial number 3.
It's too late in the day. It's too late in the day to issue this type of communications. When the entire Kharguli
Yes,
has already been done.
I got one interesting thing, Lordship. In 2012, Lordship,
Mr. Khan, if you say something more, I will only issue notice. You want that?
He is getting a disposal.
Then the instant writ petition has been filed by the petitioner, being aggrieved by the delay in disposal of his mutation application by the concerned revenue authority. The facts as could be discerned from a perusal of the writ petition is that a plot at measuring 2.26 R covered by dag number 400 of KP Patta number 1 bracket 45 Sona SANA bracket close at Revenue Village Sohor Kharguli Moja Ulubari in the district of Kamrup Metro at Guwahati was transferred by the deed of sale bearing deed number
My lord, will find at page 12 of the writ petition.
8396 dated 22/8/2019 in favor of the petitioner.
My lord.
It is further evident from a perusal of Annexure 2 of the writ petition that prior to the execution of the deed of sale, the necessary permission was also granted by the Office of the Deputy Commissioner, Kamrup Metro, on 26/2/2019, wherein it has also been mentioned that the intended use of the land was to be used as residential. Thereupon, upon the purchase, the petitioner upon purchase of the said land by the said registered deed of sale, applied for mutation before the circle officer Kamrup Metro, which was registered as GM case number 19/2019-20. It reveals from the records that pursuant to the filing of the application on 6/3/2020, the circle officer Guwahati had issued a communication to the Deputy Commissioner Kamrup Metro forwarding the report of the Latmandal in respect to the said land. It is further apparent that by an order dated 18/2/2021, the additional Deputy Commissioner Kamrup Metro, taking into account that the land falls in an FS grant, refers the matter to the Secretary, Assam Land Revenue and Disaster Management Department for approval. It is further seen from the records that the Joint Secretary to the Government of Assam thereupon issued a communication to the Deputy Commissioner of Kamrup Metro in relation to the mutation case of the petitioner, and thereby requesting the Deputy Commissioner Kamrup Metro to provide certain informations as detailed therein. The said information thereupon was furnished to the Revenue and Disaster Management Department. Thereupon, it further transpires from the records that on 23/2/2022, the Joint Secretary to the Government of Assam, Revenue and Disaster Management Department, had issued another communication to the Deputy Commissioner, Kamrup Metro Guwahati, thereby returning the proposal and seeking various instructions on the said instructions as detailed out in the said communication. It is further seen that to the said communication, the circle officer revenue, the office of the deputy commissioner, Kamrup Metro, had provided the information. Be that as it may, nothing has happened in respect to the mutation case of the petitioner for which the instant writ petition has been filed. I've heard the learned counsel for the parties and have also perused the materials on record. This court also have duly taken note of the order dated 14/8/2023 passed by this court, whereby instructions were sought from the government advocate representing the office of the Deputy Commissioner, Kamrup Metro. The instructions which have been placed by Miss M. Burman, the junior government advocate, has also been perused. This court have, upon perusal of the materials on record, before dealing with the entitlement of the petitioner, this court finds it relevant to take note of that, take note of the well-settled principles of law, that mutation does not confer any title, and mutation is done for the purpose of collection of revenue.
Collection of revenue.
For the purpose of fixing, for the purpose of collection of, no, there's a specific word used by the Supreme Court, no?
Determination and collection of revenue.
And mutation is done by the revenue authorities only for the purpose of determination and collection of revenue.
Is there, madam?
From a perusal of the materials on record, and more particularly the deed of sale, it is seen that the land has been transferred in favor of the petitioner after following the required formalities in terms with the Registration Act as well as the Act 1908 as well as the Transfer of Property Act. Accordingly, the right over the land in question by operation of law vests upon the petitioner. It is also seen from a perusal of Annexure 18 to the writ petition that the respondent authorities have granted mutation in favor of the vendor of the petitioner. And as such, this court sees no reason why the petitioner, now who is the owner of the land, should be deprived of the mutation, more so when the intention or the purpose for granting mutation is clear. on the basis of the well-settled principles of law. Taking into account the above, this court therefore directs the Deputy Commissioner Kamrup Metro either by himself to pass. Should I direct the circle officer or here? Directs the Deputy Commissioner Metro to take a call on the application so filed by the petitioner. Now, to pass either by himself or through his delegate, pass appropriate orders on the application for mutation within a period of 2 months from the date a certified copy of the order is served upon the Deputy Commissioner Kamrup Metro.
In place of Deputy Commissioner, it would be District Commissioner.
Huh?
Now District Commissioner.
What is that? It would
Apply.
be-
At number 2.
Yes, Mr. R.S. Mishra.
My lord, matter relates to cancellation of GST registration, my lord.
Huh?
GST registration, my lord. My registration was cancelled, my lord, because of non-filing of returns for a continuous period of 6 months, my lord. After I have complied all the defaults, my lord, I have filed my returns, my lord. I am paying for revocation, my lord. I could not file appeal because my the period of filing appeal has become time barred, my lord. That's why
No. There is no condonation.
They can condone the delay up to 1 month only. Beyond that, they do not have the power to condone, my lord.
Is
Section
it so?
Section 107, my lord,
Down the hook.
of the GST Act.
GST account.
In item number, my lord, 17, the authority has dismissed the appeal on time bar only. I have 3 matters today, my lord, same issue, my lord. Section
Yes.
107, my lord.
107. Yes,
Subsection 4, my lord.
may if it is satisfied that the appellant was prevented by sufficient cause from prevented within the aforesaid period of 3 months or 6 months as the case may, allow it to be present within a further period of 1 month. Now, said decision within 3 months from the date on which the said decision or order is communicated to such person. You were communicated with that decision.
It was uploaded in the.
Then why didn't you file it?
My lord, requirement is that, my lord, first I have to update all my returns, my lord. The returns could not be updated, my lord. It could be updated after 4 months only, my lord. That is the reason, my lord.
Huh?
Returns were updated after 4 months only, my lord. The order was passed, my lord, on 23, my lord. Returns were updated on, my lord.
No. Do you require to file your returns for filing an appeal?
My lord, the rule 23 provides, my lord, that for before seeking revocation, I have to update all my returns, my lord.
No. I'm asking you for filing of the appeal. Is it required that you have to update your returns?
That is not, but
Why should this court? Because it will be something like this. When the statute does not mandate, why should this court exercise the power under 226?
that's the, my lord. I am also challenging the original order, my lord.
Huh?
I am also challenging the original order. Both the orders I am challenging, my lord.
Yes.
In original order was the reason of cancellation was non-filing of returns, my lord. That defaults I have cured, my lord, now, my lord. And if my registration is revived, my lord, it will not filter the government. Rather, it will help in collection of revenue, my lord. And I will because, my lord, registration was granted in 2019. Since 2019, my lord, I am continuing my business, my lord. This time I have defaulted, my lord, and I have cured all the defaults, my lord. It will not utilize the revenue, my lord, if my registration is allowed, my lord, to revoke, my lord. And my lord,
There are judgments.
If that be so, why should we not? Why didn't you approach the authority concerned, making the same submission?
They invariably dismiss the appeal. That's why I.
Huh?
They invariably, my lord, dismiss the appeal whenever they.
So
found-
they dismissed the appeal. Thereafter, there is no appellate authority. Then you could have come before this court.
That was that I ought to have done it, my lord. That I ought to have done it.
Then why all this coming out here? Because the 1 month has been fixed by the statute for a good reason,
My lord.
that there should not be delay, and it is from the date on which it is being communicated to you.
My lord.
So you have been given 3 months for that,
Yes. Ma'am.
and first 1 month of condonation. And the Supreme Court has, in the case of arbitration and conciliation at section 34, says that you can't extend it.
That's why, my lord.
And now can we now take recourse? Just for example, in the case of arbitration,
My lord.
can we now say, oh, that 3 months or 3 plus 120 days is over? So let's entertain writ petitions. What do you say?
I am challenging the original one also, my lord.
So,
Suppose the appellate order is correct, my lord. Therefore, my lord, I cannot challenge the appellate order, my lord. But original order I can challenge because my defect was that only of non-filing of returns. Otherwise, it is not a case of fraud and other thing, my lord. It is just a default, my lord. That I have cured, my lord. Therefore, my lord, I am also challenging the original order, my lord.
where is the original order?
My lord, it is at page 24, my lord. At 25.
Ah,
Reason is that
this
reason
has
is
the
cancelled.
reference to your reply dated in response to the so-called note, whereas the undersigned had examined your reply and submissions made at the time of hearing any. See the order of page 25?
Lordship,
What is the reason?
Lordship, may come to 24, page 24, notice.
No, forget about this. What is the reason given here?
No, Lordship, on the basis.
No,
of
no, no. What is the reason given here?
Cancel following reason, registration is cancelled.
What is this? You are saying is of the opinion that your registration is liable to be cancelled for the following reason. Reason is registration cancelled.
Lordship, the notice.
No, forget about notice. This order, if Mr. Kyle just tell me if a notice contains everything, and the order says we are cancelling your registration because the registration is cancelled.
That should have been given as per the notice.
You set aside this unnecessary type and and do whatever you like.
No, my lord, an opportunity given, my lord, I have to.
Huh?
An opportunity given, my lord, to place my case before authority. Because default has been cured now, my lord.
So-called notice for cancellation, returns furnished by you under section demand, observation, failure to furnish returns for continuous period, you are hereby directed.
He filed his reply also.
Hmm?
He filed his reply
was
also.
not filed. It is a.
He said
You did not file a reply. Oh,
Lordship, it is reflected in the page 25.
Hmm.
This is in reference to your reply dated 15/2/2023. In response to the notice, so-called dated 15/1/2023.
so there is no reply also. And if there is no reply and he has made a reference to a reply.
He made a reply, Lord.
No, I have made a statement, my lord. I have made a statement in the petition, my lord. I have not filed a reply. It is a computer generated order. my
Then,
lord.
Lordship, I may be allowed to produce the record on Tuesday, Lord.
But what
No, that-
remains here?
That is there.
You want to, you may be said that some files are missing in your chamber, so you want to increase the volume of the files. It's good.
No, that is. Lordship, here, I agree with your Lordship's observation that reasons should be clearly stated in the cancellation notice.
Huh?
As reflected in the so-called notice, that ground must have been reflected in. So this cannot be a ground.
It can't be. You can't discuss it. We set aside this, and what else to be done now? And shall consider his case. We only set aside this, leaving the authorities to take necessary action, and also take into consideration that in the meantime they have filed. I think that is the best way.
Lordship, what happened? There was a amnesty scheme. The registration which were cancelled up to 31st December 22, they were required to be restored Up to that, earlier it was June two thousand
No,
twenty.
his cancellation happened on 23/3,
Yes.
2000.
This scheme will also not cover.
No, we set aside this, giving the liberty to the authorities to take a call and also take into consideration that in the meantime, the petitioner has filed his return.
Not-
I think that is a win-win for
that-
both of you.
That will,
The instant writ petition filed challenging the order dated order bearing number ZA 180-323-021-425 X dated 23/3/2023. Asked by the respondent number 4, cancelling the GST registration of the petitioner. The facts, as could be discerned from a perusal of the writ petition, is that the petitioner herein was granted a registration under the which one?
Central GST.
Central GST Act 2017, and was issued a certificate on 29/8/2019. However, why you could not file your return?
Because of acute financial hardship, my lord.
However, as stated in the writ petition, on account of acute financial hardship, the petitioner could not file his return. A show cause notice was issued on 15/1/2023. By the respondent number 4. Asking the petitioner to show cause as to why his registration should not be cancelled for not filing the returns under Section 39 of the Central Goods and Service Tax Act 2017. In the said show cause notice, it was also mentioned that the registration of the petitioner was suspended with effect from 15/1/2023. Where have you made the statement you have not filed your account? Reply.
My lord.
No statement.
My lord,
Huh? Mr. Mishra,
I am sorry, my lord. I have made in paragraph 4, I have said my proposal was,
Era,
paragraph 4, I have said, my lord. Proposal student, I was asked to furnish the reply, my lord.
then where have you stated you have not filed your reply? We allow it with a cost of 10,000,
I'm sorry, my lord. In
15. You made a false statement.
I'm sorry, my lord.
Absolutely.
In-
You made a false statement.
I sorry, my lord. In-
No. There is no sorry. The cost is upon you, Mr. R.S. Mishra, to be paid to the lawyers,
Legal service of.
not legal services. Now they have, the Bar Association has some fund, no? This is better. Why have you made this false statement?
Actually, I got confused there.
There's no confuse. That was the specific question out there. And you said that when Mr. Kyle said that I'll go to the records, then
I'm sorry, my lord. It may consider, I'm.
Cost. It is not known, however, it is not known as to whether what show cause notice reply the petitioner has filed. As they say, the reply to the show cause notice is not a part of the records. Be that as it may, on 23/3/2023, the respondent number 4 cancelled the registration. On the ground that the registration is cancelled. On the ground, registration is cancelled, inverted comma. Huh? It is also seen from the records that the petitioner claims that he had filed his returns thereafter in terms with Section 39 of the CGST Act 2017.
Returns have enclosed page 26, ma'am.
This I am not going to believe. Thereupon, the instant writ petition has been filed challenging the order of cancellation dated 23/3/2023 by way of the present writ petition. I've heard the learned counsels for the parties and also perused the materials on record. It shocks this conscience of the a perusal of the impugned order dated 23/3/2023 would show that the said order is passed by a quasi-judicial authority. And as such, further, the effect of the said order is that in absence of a registration, would be that in absence of a registration, the petitioner cannot carry out its business. Therefore, the effect of the said order impugned would entail civil consequences. In the backdrop of the said, if this court peruses the order, it is shocking that the respondent number 4 had cancelled the registration by giving a reason that registration is cancelled. This clearly shows a total non-application of mind, apart from the fact that reasons aside, apart from the fact that the impugned order is devoid of any reasons, any justifiable reasons. Accordingly, this court therefore sets aside the said impugned order dated 23/3/2023. Thereby, restoring the status back to the as on 15/1/2023. when the show cause notice was issued and thereby restoring the status back to the date on which the show cause notice dated 15/1/2023 was issued. Full stop. The petitioner herein is given the liberty to submit. The learned counsel appearing on behalf of the petitioners further submits that in the meantime, the petitioner has already filed his returns. These aspects of the matter can very well be taken note of by the respondent number 4. And there, for which liberty is given to the petitioner to submit, to file an additional reply to the show cause notice, bringing to the notice of the respondent number 4 about filing of the returns, as well as any other grounds which the petitioner deems it proper. The said be done within a period of 10 days from today. And thereupon the respondent number 4 shall take due steps in accordance with law. With the above, the instant petition stands disposed. Thereby stands allowed to the extent of setting aside, stands disposed in terms with the observations and directions made herein. Cost,
Item 18 is same. Same.
In 18, I have made the statement, my lord. The reply was not filed. I got confused with item 18. I am sorry, my lord.
So here cost is 10,000, there no cost.
My mistake, I am ready to clear, my lord. This was my mistake. I got
Hey,
confused.
green book bharai lao. Naam to. Next.
18.
18 same.
17, same, but my 17, what happened, my lord? Appeal was filed.
What is the reasons assigned?
Same, my lord.
Same.
Then what is there? Same it will be.
My same, lord.
Date will be different.
They different and my lord, period of cancel different, my lord. Written filing paper.
I have not said anything about the period.
But
I have only said
Yes.
about what is there.
Otherwise same.
I give you the liberty to file your reply.
My-
That is what I have said. I have not stated whether it is you filed or
my
not.
lord. Sir, Item number,
This both.
item number 17, my lord.
17 or 18?
18 same.
Ah.
And thereafter 17 also same issue, my lord. Here, appeal was filed, appeal was dismissed at time, my lord. In item 17,
So there we will take note of later on
sorry.
when the 17 comes.
Not-
18 is same,
Yes, 18 is same.
I'm
18 will
I am
pass.
again taking apology, my lord, for that statement. I am sorry.
Huh?
I am taking apology for that statement. I am sorry.
We
my
have
lord.
put you in the green book.
It was my
Next,
mistake.
it will
my lord.
come to the red, then the black.
Oblige them.
Number 3. Yes. Finance is there. What is there? Oh, this one. Disposed. Who has, when did you die?
My lord, 19/5/2020.
Okay. Consider and disposed. Very bad. 6 months. Earlier 3 months, now still in 3.
The respondent number 1 and 3,
But 1 and
because one has to approve the sanction.
we'll direct the commissioner only. The commissioner will take care of it.
Well, I'm-
It is 8 to 15, 11, 2000. 4.
Oh, my lord, in this case, lord, petitioner number 1 is the wife of deceased whose husband was serving as government grade 4 employee under the health and welfare department. He after retirement expired, my lord. Now they applied for next of kin certificate. My lord, that is page 37. Leaving 2 wives, my lord. Petitioner number 1 here is the first wife and respondent number 4 is the second wife. So after application, now the page 39,
they have OPC respondent, my lord, given a remark. After filing our application, the private respondent number 4, second wife, he has filed another application. Mentioning her name, it's serial number 1. So in that, and produce some affidavit of my divorce, notary affidavit. On the basis of this, my NOK are not given. Page 39. Official remark.
Are you? Issue notice,
I have also filed representation, page 40.
will no, issue only notice, nothing more than that. Issue notice, making it returnable on. এই এখন নতুন ক্যালেন্ডারখন কত? Making it returnable on 9th of October 2000. Today is 9, na? 9th of October 2000. 9th of October 2000. 10th of October, 11th of October 2023. Mr. Arbor Buzari, who? Mr. P.R. Mohanto appears on behalf of the respondent number 1. Ms. Lorenzo M. Borman appears for respondent number 2 and 3. Extra copies of the petition be served upon them by Monday, 11. As regards the respondent number 4, steps be taken by way of registered as well as usual by 11/9/2000. 6. Yes, what is this case?
My lord, this is regarding my lord, killing of my petitioner sons.
Huh?
Regarding killing of petitioner sons by unknown extremists.
Will issue notice.
Yes, my
in this. আগৰটো নিচিনাই হ'ব notice খনত এয়া হ'ব who is appearing for the union? Oh. Miss M. Borman appears for আগৰ নিচিনা issue notice making it returnable. Let us have it on 12th of October.
12th of October.
I think affidavits needs to be filed. We'll have it after the recess.
It needs to be filed.
Yes, we will do and on 6th of November. Miss. Oh, madam, you're there. B. Sharma appears on behalf of the respondent number 1.
2, 3 and 5 to 8 I
Hmm?
2, 3 and 5 to 8 I am.
Miss M. Borman appears for the respondent number
2, 3,
2, 3,
then 5 to 8.
5, 6, 7, and 8. And Mr. Arbor Buzari appears for the respondent number 4.
Man,
4, na?
4.
As the respondents are duly represented, extra copies of the petition be furnished by 11/9/2023. The respondents are directed to file their affidavits on or before 6th of November.
I am obliged.
May I pray, my lord, name of SC revenue may kindly be shown in the constance because they have not served copy on us. Although revenue is a party, I have checked the record, my lord.
The registry shall also show the name of Mr. Arbor Puzari representing the SC revenue. Representing the revenue department.
I'm so obliged.
Like,
Yes, madam.
Lordship, the petitioner's house was taken on rent by the PWD department, Lordship. And since 2005, therefore, Lordship, 2015, up to 2015, they paid the rent. Lordship. And enhanced rent or the reassessed also in the meantime, but Lordship, after 2015, they have not paid. So I have filed one writ petition,
What is that order? Let us see.
Lordship. Para 7 of page 30, Lordship.
Then what happened? Why you have not filed a contempt?
No, Lordship. Thereafter, I filed 2 representations before both the authorities, Lordship.
There is already a direction. What else does this
An
court have to do
amount,
now?
Lordship, an amount of 3,45,000 they have paid. My area rent becomes 3,70,000, Lordship, almost, but
3 lakhs
70.
and 345 they have paid.
45 they paid, but Lordship.
So
rent
we
was-
are on 35,000.
No, Lord, the rent was not re-accessed from 2015 to 2019, Lord. I am on that prayer, Lordship. The circle officer was, there is a clear direction, Lordship, last part, the circle officer Karimganj is also directed to furnish the revised rent applicable under the Assam Urban Area Rent Control Act. And accordingly, we
No,
have
you
filed.
have been paid this amount from where to where? This is the amount paid.
Yes, Lordship, since 31/10/2015 to Lordship November 2019.
How much you have been paid?
3,45,000 in para
Where is it?
11 I have mentioned.
No. What is this page 26?
Page 26, Lordship, before filing of that earlier writ petition, there was a calculation,
Ah,
2,77,000, Lord.
now,
That was up to September 18, Lordship, but they vacated the house only in the month of November 2019. Lord. So up to November 19, my area rent was there, and since 2015, 31/10/2015, the.
okay, we issue notice only, madam, nothing more. than-
Lordship, only Lordship. Lordship.
কি আগৰ notice হ'ব? Mr. P. Nayak, you are representing? For 1, 2, 1, 2, 3, 4, and 5. With M. Borman appears for respondent number 6, আগৰ নিচিনা. Issue notice making it returnable by 8th of November.
I'm deeply upset.
আগৰ নিচিনা. 8. Yes, Mr. Day.
Yes, please, my lord. Lord, wherein the petitioners are residents of 2 villages under Patharkanti Revenue Circle in Karimganj district.
Hmm.
My lord, on the 14th of July 2022, the officials from the Revenue Circle office had come and directed them to vacate their plots, my lord. And on the 16th of July,
Eviction has been done.
done, my lord.
Then what remains?
My lord, we want the possession of the land be restored back to us because, my lord, we had procured the land through registered sale deeds, my lord, executed.
From?
My lord, those are registered sale deeds, so we believe that the persons whom we had purchased it from were settlement holders, my lord. And
Settlement holders?
my lord,
How
Have
did
the
they
right.
become settlement holders?
my lord, they had the possession and also their names were recorded in the revenue record, my lord.
Now, how they became settlement holders? Under the Assam Fixation of Act 1956?
My lord, their settlement.
Or they were settled under the land revenue regulation?
That exactly, I'm not certain, my lord.
Then-
But we had procured it through registered.
Why
sale
you
deeds,
were evicted?
my lord?
Why you were evicted?
My lord, that is what we had documents, but we were not given a chance to show cause as to why we should not be evicted, my lord. Neither there was any determination of our rights over those lands.
Hello?
My lord, in similarly situated persons had approached this honorable court earlier, my lord,
Hmm.
and
The petition was registered as 5047 of 2023.
Notice has been issued only. এখানে কি order দিব? Miss P.R. Mohanty appears for respondent number 1, 2, 3, and 4, Miss Esham. Returnable on 10th of November. Issue notice returnable on 10th of. The respondents are directed to file the affidavit by 6th of November.
9 month apply.
Yes.
But if in this case, petitioner minor girl was raped and murdered.
Huh?
Minor girl of the petitioner was raped and killed by a person method. So
How do you know?
that is police FIR and social laws, police report by
Have you filed an application?
my lord.
What did they do?
They have issued notice. I have been asked, but nothing has been done.
What? Issued notice when?
Issued
You filed it on 16/6/2023 before the district.
My lord.
You have time till two months for passing of the award. And how have you filed this? You have come under the Assam Victims Compensation Act. Have you seen Rule 6, Rule 5? See? My goodness. Withdraw. Dismiss. Withdraw. Which one? Withdraw. The learned counsel appearing on behalf of the petitioner submits that taking into account its clause 5 of the Assam Victims Compensation Scheme 2012, the petitioner is not going to press the instant writ petition and would pursue his remedies before the state legal district legal services authorities. Which one? Dhubri? Kokrajhar. Full stop. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberty. Full stop. But it is made clear that the withdrawal of the instant writ petition shall not prejudice the rights of the petitioner to the claims as made in his application on 16/6/2023 before the chairman, district secretary or chairman? Secretary, District Legal Services Authorities, said the district Kokrajhar.
The only thing, if I may most humbly draw your lordship's attention to page 28 of lordship's
Is
brief.
withdrawing.
Yes, my lord. He has to apply within 6 months of the date of the crime. My lord.
We will see whether it happens or not.
11
I am up.
Madam, you are saying about 6 months. That is the case under 357A4.
For the victims compensation.
No, it is only in respect to say section 377, 357A4.
My lord.
His case wouldn't come
yes.
within it.
Petitioner's Nehripatta land has been occupied by dumping debris over it. Under Borak Novumi project, your lordship, from the river bed of Borak, your lordship, they extracted and pressed the sand sealed.
Your land has been taken?
No, lordship. Forcefully they have dumped, and since 2017, your lordship, it has been occupied by sand, seal, mud, clay.
Who has done it? Who has caused so much of grievance to you? Tell me, Mr. Counsel.
Lordship may kindly see.
Inland water.
Page number 25, your lordship. This is our representation before the deputy commissioner.
Hmm.
And based on which your lordship, annexed the page number 26.
Mr.
Additional-
Counsel, I think this is a case where we have to issue notice only.
Yes.
Okay, notice issue ko ready po. Who appears for inland water? You are appearing? Revenue. Who appears for inland water? Union of India, none appears. Inland waterways, Uttar Pradesh, none appears. Director, so and so. Inland Water Authority of India, none appears. Okay. Lekhok, issue notice making it returnable by 10th of November 2023. Miss P.R. Mohanta appears on behalf of the respondent number 4. Ms. S. Sharma appears on behalf of respondent number 5 and 6. The said councils, extra copies of the writ petition be served upon them by 11th of September 2023. It is relevant to note that the Union of India is not represented. This is item number 11.
Yes.
Though the name has been shown in the cause list. Under such circumstances, this court directs issuance of notice upon the respondent numbers 1, 2, and 3 by way of registered as well as usual by 11th of September 2023. The respondents are directed to file their affidavit on or before 8th of November.
Like-
Well, yes, Mr. Mahajan.
My lord, with all respect, my lord, a visually handicapped my lord, employee of Braille Place, my lord, he got appointed in the year 2008, my lord. And thereafter a quarter was allotted to him as per the handicap norms, my lord, in 2009. Thereafter in 22, my lord, he vacated it on its own because it was absolutely human beings could not stay there at a point of time, my lord. And thereafter now what has happened, my lord, there is another cottage attached to mine, my lord. There is private respondent number 5, my lord. And we filed an RTI. In that RTI, my lord, that is at my lord, with all respect, my lord, page 35, my lord. RTI is at page 33 and the reply is at page 35, my lord.
Now, what do you want, Mr.
Only,
Mahajan?
only, my lord, notice and my lord, it should not be allotted to respondent number, anybody else, my lord, during that.
Yeah.
Because, my lord, that one rule says, my lord, because the Braille page, my lord, at page 39, my lord.
We can issue a short notice, that's all.
Can I just take another, in the act itself, my lord?
No, whatever may be, I'll only issue a short notice then.
Fine.
We'll get you his instructions.
My lord.
It's not a case, but. And it is lying vacant. Cottage number 5 is lying vacant.
Vacant. It's page 38.
So notice making it, who is representing the respondent number 1, 2, 3?
Yes. GSM, my lord. 1 to 4.
Who is appearing? 1 to 4. And why you are making Indira Bora? Indra Bora?
Because his two cottages were allotted, my lord. Mine was next to him. Now, my lord, on the query, it has been found out that government has not done it. We have stated in our petition, my lord, that he has been doing it on his own, so that he can grab it can be extended and he can take care of it. Take possession of it. Sorry.
Was the imperial to out
Para
the
20,
petitioner from his
page 11, para
government
20.
quarter to accommodate the private. Now you have been you already vacated it.
I vacated it on my own because.
So then why you are asking for quashing?
Because it was, my lord, at a point of time, human beings could not have lived there.
So why you are asking for quashing the decision? You are asking to
Well, we
quash the impugned decision of the authorities to oust the petitioner from his allotted government quarter, that is cottage number 6, to accommodate the private respondent.
my lord,
When you have vacated it on
I
your
vac-
own,
I vacated, my lord. There is a rider. I vacated it, my lord, because I am to pay rent for the house, my lord. I vacated it, my lord, so that because it was allotted to me officially, my lord, with all respect, my lord. I vacated it, my lord, that, and I said to the authorities, the rent, which is, my lord, from my salary, it is deducted, my lord. That should not be deducted meanwhile.
understood. Where is their order? Decision?
Yes, my lord. That is that page, my lord, with all respect, my lord. Page 22, we were allotted a house, my lord.
No,
And
where
on
did you,
occasion, we wrote
decision
that
to
page
vacate?
25 and 26, my lord.
Huh?
Page 25, my lord.
Is lying vacant is hereby allotted to Diganto the proof reader of the office of Transport
Honorable-
India until further order on payment of electricity bill. Then
Yeah.
page
Page, my lord, 26 is the Bharnekula, my lord. when I left the house, my lord. And 25, my lord, that salary, my lord, rent part, my lord, it should not be deducted from my salary. My lord. Let there be a short notice, my lord. And my lord, lordship, that.
But why you are challenging that? You on your own have done it.
My lord,
Then where is the question of challenge to that?
that is also lordship is correct, my lord. Lordship, but
Yeah.
kindly have a look at, my lord, with all
Do
respect, my
not
lord.
be directing the respondent
Page
not to
31.
oust the petitioner from his allotted quarter. You have by yourself.
I have vacated it, my lord. House is intact, my lord.
So why are you asking for B? Kindly see
The
page.
language lordship is correct. I have understood.
A retainer should not be issued directing to provide reasonable accommodation to the appropriate barrier-free and conducive environment to the petition.
My lord, that is the other person, my lord, respondent number 5, my lord. He is neither handicapped nor, my lord, an employee of the trade base. We have made specific amendments.
But where are you asking for an interim? Show me.
It-
Direct
my lord,
to not
clear, my
to
lord.
not to allot the quarter number 6 to any third party. You have left the quarter number 6.
Lordship is-
Then why are you asking that quarter number 6 should not be given to anybody else?
My lord, after it being repaired, my lord.
Where is that?
My lord, yes,
I think better you withdraw and file a fresh one. What is all this type of things which has been?
Can the application-
Later on, you will have a difficulty. This is only a case. I mean, this is a case where the notices should be made returnable in December now, not in September. And at the end of the day, you will be in trouble. You are asking for certain reliefs. I don't understand as regards 6.
that I should not-
You have by your own volition you have left it. Then now where is the question of you asking for that?
My lord, it was allotted to me.
You were saying that provide if by any chance they, after hearing me, they did not. But if they want to repair it, then they should allot it to me. That is your case.
Correct. Yeah, I understand, my lord. But my lord, it has not been done by the authorities, the repair job, my lord.
Why should this court exercise 226 in these type of matters? This is not a case. You have on your own volition have done it. It is something like in a rented house. You say that, okay, the landlord is not repairing properly, I vacate it. But then you go and file an injunction petition somewhere. Then look here. If you repair it, however, but you have to only give it to me, not to others.
That is correct.
Can you maintain it?
Well, only one thing, my lord.
Yes.
What the law says, my lord, regarding these disabled persons, my lord, with all respect, my lord, may I just,
No. As regards a disabled person, a person is entitled to, that's another aspect of the matter.
yeah,
For them, various benefits has to be given under the public,
Yes,
that
That
Physical
act-
Disabilities Act or
yes,
something.
yes, yes,
It is another aspect of the matter. That is the different aspect from considering here.
good question is, remains, my lord. Lots of story will remains. Yes,
You are to develop your case in that manner.
my lord.
That being so and so, either you provide us something as per the Physical Disabilities Act. Now, there are various provisions out there. In fact, a person can't be even, if he is not able to do anything also, you can't retire him.
My-
Many other various provisions. Take those benefits.
My, we,
Do that matter in that
my lord,
manner.
meanwhile, we wrote to the authorities, my lord. The authorities replied in this manner. I mean, that's time we are placing it before a lordship, my lord. And the authorities replies, my lord. Page 31.
Hmm. Yeah.
Page 31. My lord, this is on my application, my lord. Second paragraph, my lord, with all respect, my lord. It is to be mentioned that as per so and so, 22 of the Rights of Persons with Disabilities Act, every government establishment shall provide reasonable accommodation.
So you better your case on that aspect. You have a case. It's not that you don't have a case. But you have to proceed in that case when that too when the commissioner has also written this.
Right.
You are not proceeding in that. You are saying that quarter number 6 is there. I left it. And you said not to vacate me. What is this type of prayers you are having?
Yes, correct, my lord. My lord, in page 16, we have given that prayer, my lord. That, of course, my lord, that may be on a wrong motion.
This will be unnecessary. We do one thing.
100%.
I can give you one thing. We dispose it of giving you a liberty in terms with that commissioner's letter,
My
to
lord,
submit a representation to the authorities who shall duly take.
my lord,
I think that
My
is the only way
my lord,
left,
my lord, my lord, oh,
nothing more than that.
yes, yes, very happy.
I think that is the best way.
Yes.
Well,
Another second.
Dispose.
Obligement.
Spent on that land, the respondent number 628 has by a fraud document mutated a land in the name of one person, Zakir Hussain. Kindly come to page. Come to page 23, annexure 6, my lord. If Lord could understand that case.
What you are asking?
I have given NOC, one NOC was given, that was been suppressed, that I was the original holder of the land, original holder, and I'm still in possession of this particular land, I'm still situated in particular land, but our document was suppressed by them. Kindly come to annexure 6, page 23, land has already been mutated.
Annexure?
Transfer, it was transferred, my lord. Kindly come to page 23, annexure 6. Mutation was not done, transfer was done. আমাদের নাম- Till today, they have not taken any hearing from our side.
Then
So till today, my lordship, they have not taken any hearing from our side. We are still in possession of the land, we are still in that particular way.
so there is a sale deed
Cell deed is there, my lordship.
on the basis of an NOC.
Yes, my,
So file a civil suit. How can this court look into this? Tell me. You want the cancellation of a sale deed? Can this court cancel a sale deed? No. It may be a case of fraud.
fraud, my,
But if it's a case of fraud, how can this court adjudicate that? Tell me.
at least they should, from our side, the hearing may be taken, that what we.
Understood. Now the sale deed has already been executed. Isn't it?
Kindly come to page,
Yes, you see that particular document, this state. Consequently, necessary land transfer has already been executed under the above daga and patta as well as on the strength of the NOC so issued on the basis of the report. So this may be a good document for you to prove that the NOC was a fraud being committed. How can this court adjudicate this? A sale deed. Has the sale deed been executed or not? Yes, you are asking for cancellation of the deed also. See, cancelling the deed dated 16/6/2007.
2000, it is wrongly written 2023, my lord.
23, you have mentioned is 2027.
Yes, I have.
That?
Yes, my.
File civil suit. What do you want to do?
Withdraw. We want to
Dismiss it.
withdraw. We want to withdraw.
The learned counsel appearing on behalf of the petitioner submits that taking into account that the disputed questions of facts would be involved, taking into account that there would be adjudication, that the dispute involved in the instant writ petition would require adjudication of disputed questions of facts as well as the element of fraud, which can only be adjudicated before the civil court. He submits that he would not like to press the instant writ petition. The learned counsel, however, submits that the withdrawal of the instant writ petition should not prejudice the rights of the petitioner to assail or to challenge the deed of sale so executed in favor of the private respondent number 6, 7, and 8.
It is, sale deed is at page 15, track type portion, annex 3. And the annex
Sale deed is that
page 15, annex 3. And original is at page 16, 17, 18, 19.
your sale deed is at page 11. You don't know. You have put the power of attorney at page.
Page 11, the fraud
What
sale,
power of attorney is page 11?
yes, annexure 1, page 11, page 10 is the.
Where is the sale deed?
Sale deed at page, fraud sale deed at page 15, annexure 3. Power of
Not
attorney is page
prejudice the petitioner in assailing the purported deed of sale in favor of the executed in favor in favor of the respondent numbers 5, 6, and 7.
This was 6 to 8 minus.
6, 7, and 8. Taking into account the above, the instant with petition stands closed on withdrawal. Full stop. It is made clear that the withdrawal of the instant writ petition shall not affect the rights to challenge the deed of sale before the civil courts if the petitioner so before the civil courts.
Item 14.
Before the appropriate competent civil.
Regarding victim compensation, my lord, the judgment started from page 20, my lord, and the recommendation at page 42, my lord. Page 42, my lord. From third line, my lord, top. I find victim of this case. Accordingly, my lord, the father of the petitioner, my lord, filed petition, my lord, at page 44, annexure 3, 13/2/2020. Because at that time, my lord, the petitioner was minor, my lord. Accordingly, my lord, the DLSA has issued notice at page 45 type 2B and vernacular page 46. Fixing the date on 26/2/21. Accordingly, the father of the victim was appeared, my lord.
So there is a direction for payment of compensation under 357A,
357.
and thereupon you have applied
Yes, my lord.
in 2020. Then what happened?
Only notice, my lord, issued, my lord, and Harry was
What
contacted
is
at
there to hear these matters?
page
Who
40,
is appearing for the district?
page 45, the notice, my lord, issued by the DLSA.
Who has filed that application?
Father filed the application, my lord, page 44,
Father of the victim.
victim, my lord. And father already died, my lord.
Huh?
Expired, my lord. After that, my lord.
So here the maximum is 5 lakhs.
Yes, my lord. As per notification, one
What about the Nalsar scheme?
Nalsa scheme is not applicable in this case, my lord. My lord, in the Nalsa scheme, it is strictly prohibited, my lord. The POCSO cases is not covered under the Nalsa. Unless and until, my lord, the new scheme is framed under the POCSO Act, my lord. And in this regard, the Nipun Saxena case, my lord, is
Because the Nalsar scheme gives up till 10 lakhs. Huh?
yes, my lord, 10 lakh. But this is not applicable in the POCSO case, my lord.
Now the victim is alive.
Yes, victim is alive. Father expert. And there is a rule also, my lord, under the POCSO Act, my lord, rule 7 in the 12th rule and the new rule, my lord, 20, rule 9 of 2020, my lord. It is, my lord, this is the POCSO Act. My lord.
Yes, what do you have to say? Is home and political? Yes, what do you have to say?
Noted. I'll obtain instructions.
Instruction for what? Instructions for what?
Why his claim is not.
Kindly see this judgment, annexure 2, page 20.
A clear direction, Manu.
Hmm?
There's a clear direction to the DLS.
Then why they are waiting for it?
DLSA, my lord, my learned colleague, Ms. Sirathia Chaudhary appears. She is the counsel.
There is a clear-cut direction to pay. Why have not they not taken into account?
And that part, my lord, under the rule framed under POCSO Act, my lord, it is.
Disposed, allowing you may, only thing is how it is to be worked out is that the petitioner has to approach.
My lord, he
What
was
is it?
asked to appear, my lord, on the at page 46, my lord, he was asked to appear.
No, father was.
Father died.
Father expired.
You see the problem which arises, Mr. Balbuzari. The father died. The father died. Now she's a victim. She's just 18 years, as could be seen from the affidavit. So under such circumstances, she would present it before the secretary DLSA, and they will pass the award in terms with within 2 months, and thereupon the direction is to be given to the home and political for the purpose of granting the making the necessary sanction and disbursal there after 2 months thereafter. So and so. We'll dispose it of.
Regarding timely period, my lord, I want to say one thing, my lord, under the rule framed under POCSO Act, my lord, prescribe 1 month period, 30 days, my lord.
You are not under that scheme. We are under the victims compensation scheme. So that is 2 months
2 months.
for the award.
Yes, my lord.
Although the award should have been passed in 2020 itself.
Yes.
Yeah. You filed it on 13/2/2020.
Yes.
Your application.
Yes, my lord.
So it should have been done with then only, but that has not been done.
Yes.
So now, however, with the certified copy, it has to be done within 2 months, and thereafter that will be sent immediately to the Commissioner and Secretary Home and Political, and the Home and Political thereupon shall within 2 months disburse the amount, so that the amount is to the Secretary who can disburse it to you.
Yes.
This is the only way out.
Obliged.
15. So এনেকুৱা order আছে বুজিছে? খালি অকমান আগৰ facts খিনি বদলাই দিব লাগে। Yes.
That is a lot. But the petitioner, my lord, the father of petitioner, my lord, was causing, my lord, 10 bigger, 2 kata, 1 less of land, my lord. They admittedly government land, and their name was recorded, my lord, in the draft there. And the respondent number 5, my lord, is a teacher, and his father also occupied land. And subsequently, my lord, one portion has been converted to, my
Mr.
lord,
Ali, what do you want?
my lord, only, my lord, representation of page, my lord, 27, we have filed and complained before the deputy commissioner, my lord,
Regarding?
regarding the anomalies, my lord, regarding settlement and
page 30, my lord, the vernacular and page 27.
Hmm.
And it was
Page?
forward, page 27, my lord. Original one is page 30. It was forwarded to resident settlement officer, my lord, for disposal. He is not taking any action, my lord. Or Divyansh, my lord, this
Hello.
application, lord,
Any issue notice. Issue notice making it returnable on 10th of November. Pune. You are challenging against whom? Only one. Respond number 5,
not,
not others.
No.
Why?
because he's the, my lord, original man, my lord, behind the,
He,
my lord,
his
respondent
master, MASTER.
lost it.
Then
And he has converted government land in his name, my lord.
he is a minor. Isn't he a minor?
Teacher, my lord. Master means my lord, teacher, my lord. Government school teacher.
Okay. S. Sharma appears on behalf of respond number 2, 3, and 4. Mr. Spencer N. Bodley appears for respond number 1. It's extra copies by 11. Steps upon respond number 5 by 11 by registered as well as usual.
Reading my lord, pendency representation that is pending.
Absolutely no.
16.
Yes, Mr. Khan.
Land acquisition matter of the land of the petitioner.
Setting aside the impugned letter dated
Page 58.
8/7. Let's see, we're page 58.
58.
Ladies and payment of compensation of government allotted land in connection with the acquisition of construction of. Yes.
The award was passed by the competent authority, that is page 47.
What authority you have to write this letter?
Oh, my lord, here the issue is this one. Land was acquired. It's land, but land is a government land. But Jirat already we have paid them. 3A notification, it is shown as government land. Then 3D also, it is been shown as a government land. But under, in between 3C comes, he has not filed any objection also to this effect. According to him, my lord, that under definition, section 3, Roman 3 R says that any land acquired, his title may be gaining after some time. Then also he is entitled for land. It may be, that is as per this law. But there would have been objection to that effect as per provision of section 3C of NS 56, but that was not coming. Now, my lord, if so, first and foremost thing, this letters whether, but it will be decided, it will be required to be decided that whether he will be entitled for land under provision of definition 3 Roman 3 R. Lordship may have kindly R. That's it. What his prayer.
No, everything is understood.
Yes.
You have a competent authority as per the act.
Yes.
The competent authority decides.
Yes, ma'am.
You may not pay the compensation. You may refer it to the arbitrator. You also have the right.
Yes, I have to. Sir.
But what is all these things? This issuing of a to the competent authority to that effect. You may say that this may be, you may say in view of the above, 3G award submitted by so and so is returned and not accepted. You can't say that you can't accept. You may say that you make a reference.
That is
That's
correct.
all.
That is correct.
But how
Because
can this be there?
Kala, we have to go 3G 7, 5, we have to go.
3G 5.
5, we have to go for that. That is your lordship vision. Now, if this.
Because
so-
if we allow this type of communication, it will have a long, it will have far-reaching consequences.
Yeah, that's correct, my lord, because it will be going probably.
Yes,
beyond
you can
provision-
very well say,
Beyond provision of law.
you can very well say that we
Yes,
don't
yes,
accept
that's
and we require you to refer it to a arbitrator.
Yes, yes, we,
So-
Kala is the authority, other, until otherwise it's been, this will,
Because you can't, return back
yes,
the
lordship-
award, because it
lordship,
will
yeah,
have far-reaching
Lordship, I'm
consequences.
making on that point.
Hmm.
Lordship, I'm making on that, and no doubt, there's
Hmm.
no doubt at all on this. Against Kala, the assessment of Kala, either word is either. We can also go-
Either of the parties, the
Either of the
amount on
parties.
an
We can- I can
application
also
by
go,
either
he
of the
can
way
also
be
go.
determined by an arbitrator to be appointed by the central
My
government.
lord, my lord. If so, then whatever we look into the paper.
We'll have it on Wednesday. Take your instructions. You withdraw this letter and you say that you will file appropriate application for referring.
Lordship,
I
lordship,
think that is the,
lordship,
take instructions on this aspect.
Wednesday, my lord. Oblige.
I think that is the only way
That is
of
the way. That is the correct, my lord. Lordship is everywhere. Oblige, my lord.
Mr. Seabold were appearing on behalf of the
IDCL.
NHIDCL
Three.
submits that he would take instructions in the matter as regards the impugn communication.
My lord.
Place the matter again on when it.
Wednesday. Oblige.
Now 17.
Yes, for that matter. Here what has happened?
The appeal was filed, my lord. That was rejected on the ground of limitation, my lord. The order is page 51, my lord, that order.
Where is that order?
Cancellation order, my lord. Cancellation order, my lord. Cancellation order is it, my lord? Page 29, my lord.
Page
29, my lord.
Yes, this can be a reason.
Right.
Fail to file GST returns for a continuous period of 6 months. This is a good reason. Then why should this in court interfere? But page item number 18, the order is same, na?
Same. Order is same.
Cancellation,
of registration. Like item number 2,
same order. But here it is different.
Yes, here it is. But see, here another point is there. The cancellation was done by Superintendent at Manipur Lottery.
Huh?
Superintendent GST Manipur Lottery. So probably the writ petition will not lie before this honorable court.
Oh, yes.
Against this order, my lord, preferred an appeal, my lord. Appellate authority is in Guwahati, my lord. An appellate authority has dismissed the appeal, my lord.
So what? Are you not asking for cancellation of this? Why should this court, the appellate authority tomorrow will be in Delhi? For the appellate, so the Delhi will have this jurisdiction.
I'm relying upon this judgment.
Lordship, recently Supreme Court in case of income
So
tax.
what do you want? You want only the interference with the appellate authority's order? On the ground of limitation? Show me that.
Sir, my
No, show me. Let us see the appellate authority's order.
page 51, my lord. Now,
Page.
operating part of the will find it page
Arising out of an appeal filed by the
56, my lord.
demand cancellation. Any person agree the officer authorized the appeal. Where's the ground, reasons or anything mentioned? Oh yeah, brief facts. Page 55.
56, my lord.
Huh?
Page 56 on paragraph 3.2, my lord, onwards.
To the appeal memo and the implementation of it. What are these orders?
My lord, my delay condonation petition is page 49, my lord. Because of internet ban and all, my lord, in Manipur, I could not file the appeal on time, my lord.
Huh?
Because of internet ban and other things in Manipur, my lord, I could not file my appeal in time. I have given a condonation petition at page 49, my lord.
You were to file within 14.5, 14.6. Where is the application?
49 is my delay condonation appeal. 49, my lord, page 49.
And these appeals are only to be filed through online.
Online.
But why you are to file where? From where?
My lord, I can file from Manipur also, but
No. Where are you residing though?
Imphal, Manipur. Imphal.
Why have you approached here then?
My lord, appeal was filed here, my lord. That's why I approached. Otherwise,
Huh?
appeal was filed in Guwahati, my lord. Appeal authority is in Guwahati, my lord. An order of appeal authority is passed in Guwahati, my lord. That's why I thought the lordship had the jurisdiction to entertain this appeal. And the situation was beyond my control because of this happening there, my lord. If lordship had asked them to consider my appeal on merit because of these things, otherwise authority would have my lord, entertained my appeal because of having barred of
So
section.
there was an internet ban. Where is the notification?
My lord, I have annexed. Page 32, my lord.
Why do you say that this will be banned for how many? What was the time that it was kept? It was kept banned for that period.
As per the condonation petition, my lord, it was stated 3 months, my lord.
Huh?
In the condonation petition, it was stated 3 months, my lord.
Then where is it?
If, extension of 33.
Because this is only for 5 years.
5 days.
Huh?
Clause 6 of page 32. This order
5 days.
prevent 5 days.
5 days. Then
Lordship may allow me to one, the next, next I will just take instructions if it was extended because in the application it was mentioned 3 years, 3 months, my lord. Therefore, it might have been extended, my lord. That's why it mentioned in the application 3 months, my lord. In the delay condonation application, the applicant has mentioned 3 months. There are 2, my lord, page 49.
so here the delay would have been. You could have filed till 14.7.
My lord,
14.7.
my lord,
You filed it on 2.8.
2-8, my lord.
So 14.7, was there any internet ban?
That I will obtain instruction.
That is the only thing.
My lord, I will
If there was no internet ban during this period,
My lord.
from 14, the period starts from 14.3.
My lord, without
14.3 to 14.3 to 3.5, there was no problem.
there was no problem.
But was there any internet ban till 14.7?
My lord,
That's all.
I will obtain instruction. My lord.
Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner shall apprise this court and shall file an additional affidavit bringing on record any documents to show that there was an internet ban till 14/7/2023 in the state of Manipur.
Obliging, lordship.
Please the matter again on how much?
Anything to the next week, my lord. Next week on Friday, next coming Friday, my lord.
You have to file an affidavit.
Lordship.
How much?
1 week, so I will ask him to come.
Please the matter again on 18th of September.
Lordship.
19.
Very clear. उसको 9
Please, your lord. My lord, the petitioners are petty businessmen. The petty businessmen, my lord, they have approached your lordship seeking protection against certain eviction. Now, they were, my lord, allotted with some municipal land. And they were also granted permission for doing their maintenance by the municipal.
So what is the direction 6/8/2020 page?
That your lordship will find at page 111.
Hmm?
111. That is the order passed by the district magistrate.
Submitted by Commerce Ministry. Illegal. Yes. So,
My lord, my first submission will be that this is not a illegal commercial contract.
but do you have a right to construct on municipal land?
My lord, the municipal authorities have initially granted the lease. We're doing business there, small businessmen, my lord. And on our application, the municipality have taken a resolution that the land will be allotted only, my lord, 5 feet by 7 feet each of the, my lord, the applicant.
Understood, but show me, do you have a right to construct?
My lord, first, my lord, the lease was granted, that is at page 22. Then they were allowed to carry on business. And if your lordship comes to page 64, that is the vernacular order,
Yes.
by this they were permitted to raise the Pakka structure.
Page 62.
62 is the transmission, 64 is the vernacular. I think your lordship will read the vernacular.
Why? It's not an accurate translation.
My lord. I don't say it's not.
So you have been given the lease of the land.
Yes.
And therein you are to construct.
Initially, we were permitted to carry out our business in the 7 feet by 5 feet area. Then they were allowed to construct temporary structure, not permanent structure, but Pakka flooring. That is what they have done. Thereafter, this the district magistrate order came, but that is of 2020, as your lordship may have, my lord, noticed. Nothing happened. But the reason for why these petitioners have come before your lordship is that, my lord, abhorrence at page 13, paragraph 14. Because only the other day, the municipal authorities had a meeting and they are, my lord, keen on evicting.
Now, are you raising any construction?
Constructions are already completed there, my lord. We have been doing the business.
Ah.
Pakka floor and, my lord, tin roof and temporary structure. That because, my lord, the initial allotment also there was a clear direction that you would not construct permanent structure.
Now, why are you saying that they are not allowing you to carry on the business when the settlement has been given? For what period the settlement has been given, the land?
No, my lord, this period has not been stated. Your lordship will find that at page 22, the original vernacular, my lord, page 22. আজিল সভায় ব্যৱসায়ৰ বাবে মাটি বিচাৰি কৰা আবেদনৰ ওপৰত আলোচনা কৰে। আলোচনাৰ অন্তত আৰু সভাৰ কনিষ্ঠ অভিযন্তাৰ প্ৰতিবেদনৰ ওপৰত ভিত্তি কৰি বৰপুখুৰী পাৰৰ বহুমূলীয়া পাৰ্কিঙৰ দক্ষিণ দিশে আৰু চুপহীৰ পশ্চিম দিশত 5 ফুট 7 ফুট জোখৰ মাটি নিম্নলিখিত ব্যক্তিসকলক বন্দোবস্তি লিজত দিয়াৰ সিদ্ধান্ত গ্ৰহণ কৰে। Then
Lease for what period?
my lord,
It can't be permanent.
it cannot be permanent.
What is your right? In fact, yesterday I was taking up one matter where the lease was given in 1954, it is still continuing and there is a fight between the other two persons and for that. What is your right to continue in view of section 62, 148 of the Municipal Act?
62, my lord, 62 says about the my lord municipal property. That is a municipal property. There is no doubt.
And 63 and 63?
63, my lord, the property lease. Or the lease.
And 63 too?
63 to your worship will find no portal sale, sale, late exchange or otherwise dispose of any land vested under section 62 except with the sanction of the government. So whether my lord sanction of the government is taken or not, my lord, this person are my lord not aware of. So
But can it be in perpetuity? Municipal land?
it cannot be. It cannot. But then, my lord, even assuming, my lord, my rights are not only specific to legal rights, equity also is your right to be considered. These persons are doing their
Mr.
business.
Chaudhary, the only thing this court can do now is only issue a notice and say that no demolishing should be done. I'm not touching on the, not to eviction or anything if it is otherwise permissible. I'm only saying no demolition of the structures constructed till date.
My lord, and,
That is the only way.
and perhaps your lordship may also say, my lord, if so far as the eviction part is concerned, my lord, there is a procedure later notices has to be given.
Should I say something?
No,
Because
my
the
lord, I
moment
think
if I
better
say you will be in more difficulty.
Yes, right.
Issue notice, making it returnable on 11th of October 2023. Ms. M. Sharma appears on behalf of the respondent number 1, 2, 3, 4. Extra copies of the writ petition be served upon her by 11/9/2023. As regards the respondent number 5 and 6, steps be taken by way of registered as well as usual by 11/9/2023. This court further directs the petitioner to take service steps by way of dusty routed through the registry of this court upon the respondent number 5 and 6 and file an affidavit of service on or before the next date. The case of the petitioners herein is that the petitioners were allotted plots of land at measuring 5 into 7, 5 feet by 7 feet, wherein they have raised certain constructions. There is an order passed by the, where is that order?
Page 111.
111. There's an order passed by the district magistrate, Dorong, Moldoi. Wherein there was a direction that all construction work has to be stopped immediately. On the ground that any type of permanent construction is not suitable at such restricted location. This order has, however, been put to challenge in the instant proceedings. However, this order has been put to challenge in the instant. Be that as it may, the petitioners apprehend
Page 30.
that the responding authorities would now demolish the structures constructed by the petitioner, which was earlier permitted to be done, and as such have sought for certain interim protection. It is the opinion of this court that as notice have been issued, to the respondent authorities, the status quo as regards the constructions be maintained till the next date. Meaning thereby, neither the petitioner would raise any form of construction on the allotted space, nor the respondent authority shall demolish the construction standing as on today in the allotted space.
Adequate protection, my lord. Great.
Huh?
Adequately protected, my lord. Great. All right.
Supplementary list item number 53.
Hmm. Oh,
Your Honor, on last,
you're the bad case.
so I may prove that I have a good case, I can just prove it.
Oh, you got a good case. Now tell me, what is your case?
Yes, sir.
On
Sir,
that day, I was about to dismiss.
Please, sir, please, sir.
Yes,
please, sir.
now tell me.
Sir, kindly, sir, may I?
Setting aside a speaking order, setting aside and quashing the speaking order, and directing the restaurant to regularize the violation, if any, in the construction of the RCC of the by imposing fine. What is that speaking order?
Sir, to demolish the structure,
Where is it?
at page number 24, sir.
It's number 24. Yeah,
Sir, may I read, sir, one paragraph of the speaking order, sir?
yeah.
It is at page number 25.
Directed to- Yes, tell me.
Sir, kindly please pay attention to page number 25, sir. The Shilchar
25.
Development Authority rejected his petition for construction permission dated 6/11/2019
Hmm.
and intimated his decision to so-and-so by so-and-so number dated so-and-so. Dated 6/11/19, the Shilchar Development Authority in his order dated white so-and-so dated 6/11/21. So there is no such order of 6/11/2021. It may be a typographical error, and this is annexed in my as annexure number 2. It is 16/11/2021. So sir, in that order also has some defect because that order is not against me. The dag and patta are different. And in that context, I have raised the issue and it is given due representation after the speaking order to the authority. And till now that is pending, there was no adjudication about that. So I may read that representation which I have given after the speaking order. So that representation is that. Also to my, there are 2 paragraphs later. Also to my surprise, I received
Where?
in para number 3,
Of?
page number 26.
Yes.
As to the surprise, I received letter dated 6/11/19, memo so-and-so, which states that the building permission has been rejected. As per the verified will report, building is already constructed. However, another notice which I received again dated 16/11,
In the speaking order, it is mentioned 611. Memo so and so, which narrates that as per the verified field report and on receipt of complaint, the DAG number and the patta doesn't belong to me, belong to us. Also state the building is under construction. Now, sir, annexure number 1, which annexure number 1 shows that the building is already constructed. Your prayer for building permission has been rejected due to, as per the field report, building is already been constructed. And now let us come to annexure number 2. Here they have stated that the building is under construction. So my case is, sir, they never visit my site. It was just the High Court order which the petitioner was, hearing petitioner was not heard. He was in the error of list of parties, but the High Court has given the direction to the respondent number 3 to pass a speaking order. Just they found a speaking order, just direction to file to give a speaking order.
Now tell me, did you have a construction to build the house?
Sir, the building was constructed in the year 2009.
So?
That point of time, that area was, that piece of land was under agriculture, nature was agricultural land, and it was under Gaon Panchayat. And I have taken instruction till date. The area is under this one Gaon Panchayat till date. And the nature is.
So you say that the Silchar Development Authority had no right over that?
Sir, as of now, they cannot. And moreover, sir, the setback which they are talking about, the setback, I have seen the picture. I have not annexed. I can place it before the court. They are say for let us assume that we have to keep 4 feet of length to the adjacent land. I might have kept 3.5 feet. That can be there are provisions.
First and foremost, whether building permission is required.
At that time, it was not required. For that, I have made the construction. That is what I have given in my representation number of times.
Where is your statement?
I have given, sir, in my representation, latest representation.
No. In your petition,
Sir,
where is the statement?
Sir,
The
it is-
building
it is-
permission
it
was
is-
not
it is-
required.
That I was not aware and I have constructed.
No. That building permission is not required out there.
Sir, I am giving, sir.
Because it did not fall within the domain of the Silchar Development Authority.
Sir, para number 3, page number 6.
Yes, tell me.
The petitioner begs to state that since the petitioner number 2 is in good relationship, so and so, the letter has been allowed the petitioner to use the private land. That is the petitioner's state construction of saving on the state. However, however, as the petitioner was not aware of obtaining prior permission from respondent number 3, the construction was started without any permission. But that was because that time that area was.
Mr. Counsel, you understand what I am
I
saying?
understood, sir.
Or should I say in any vernacular
No,
language?
sir, no.
Tell me.
Sir, that time, sir.
I am asking you a specific question.
Yes, sir.
Whether permission was required. You were saying the permission was not required because land was in the Gaon Panchayat area.
Yes, sir.
And it was not within the ambit of the Silchar Development.
Yes, sir.
Authority.
Yes, sir.
Where is that statement?
So that statement is not here, sir.
Huh?
Sir, I'm telling you, sir.
Then,
So moreover, sir, kindly appreciate me, sir.
and now I recollect. If you want, the video can be repeated again. This is the specific question I put it on that day also.
Sir, kindly see, sir, my
And
representation.
then I said that try your luck before another judge,
Sir,
before whom this matter is
sir,
likely to.
I can, sir,
But unfortunately, the judge is not sitting and the matter has again come back to me.
sir, moreover, sir, I'm just giving this 2 more contentions, sir. One is that
Next Wednesday, the judge is sitting.
no, sir, I can, sir,
You don't have a case.
sir, give me, sir, 2 minutes, sir.
No, nothing.
minutes, sir.
doing. No, I'm not passing. I'm not dismissing it.
Sir,
Next Wednesday,
sir,
you
I
try
can,
it.
sir, show you 2 points, sir, if it is.
You are required to make that statement. Otherwise, you have to obtain permission. There's no
Sir,
way out.
at point of time, sir,
No, you are making the statement.
Sir.
Are you the petitioner in person? Are you the petitioner in
sir,
person?
the petitioner is.
I'm asking you, are you the petitioner in person?
No, sir.
So you don't know. You have only drafted the petition on the instructions of your clients.
Please, sir. Please, sir.
Is it or not, Mr. Counsel?
Please, sir. Sir,
Is it or not?
please, sir.
if you have done at the instruction of your counsel,
Yes, sir.
why didn't you put that statement out here?
Sir,
You knew it. Why haven't you put it on affidavit? Then I would have thought it,
so one more annexure I show, sir.
not
that,
necessary.
Sir,
First,
I
you
have,
show, first, we are to presume that the Silchar Development Authority has the authority.
had not the,
No, has the authority. Because it is an order being passed by an authority, we will always presume that the authority has. So you are to show that it is not. So it is your burden by putting it on by way of an affidavit. I can't help you. What do you want? Dismissal or Wednesday?
sir,
Wednesday?
sir, only
Wednesday.
only one, sir, my petition. the
Wednesday
petition
or dismissal?
petition undergoing the knee, he is, both of the knees has been.
Mr.
operated.
Counsel, the order was passed on 3/4/2023.
Please, sir.
Nothing has happened for the last 4 months.
Yes, sir, because.
So the only thing is you better try your luck on Wednesday.
I have given a representation to respond number two,
List
sir.
the matter on
Sir, I
Wednesday.
have given a
Mr.
respond.
Counsel, if you say further, I'll dismiss. List the matter on Wednesday. Now, if your luck is bad on Wednesday, again it comes back to me. Then you see,
Sir, I may, sir, you.
you don't have a case.
Sir, this
You
is-
don't have a
I have a
case.
representation before town planning, sir.
So what?
So if they decide.
Do you want to reduce this court to a post office? No, you want that this court should be a post office. You give the representation and this court directs to consider.
It is already pending, sir, before them.
So what? So what? Directing for consideration of a representation has to be based upon a legitimate expectation.
Moreover, sir.
What is your legitimate expectation?
That-
Do you know what is the concept of legitimate expectation?
Yes.
Tell me. You don't know. Don't say. Try your luck on Wednesday. Next. 54. Oh. GAT Union of India. 54.
Happy the road.
What is this?
Lordship, this matter relates to stoppage of working of national highway matter.
Huh?
Lordship, in this case, Lordship, private respondent number 10, 11 and 12.
Impugn interim order passed by the learned arbitrator cum commissioner. Order passed by the State of Defense filed by RAD. Letter issued by the commissioner to the government of Assam General Administration. Yes, now what are you challenging here?
Lordship, challenging the order passed by the learned arbitrator, Lordship, which post now has been abolished by the government.
Huh?
That post already abolished by the government, Lordship.
Then where is that order?
Lordship. Annexure 5 page 75.
For administration in convenience and in the interest of public and in order to bring administrative closer to the people by providing people. Yes, now what is your problem?
Divisional commissioner was the arbitrator, appointed arbitrator.
Huh?
Divisional commissioner, Central Assam Division was the arbitrator, Lordship. That
Ah.
post has been now abolished, Lordship.
Then
Due to that, Lordship, we have not filed, we have filed one application, Lordship, for modification of the order, Lordship, because the learned.
which order?
Yes, Lord, my Lord. That is annexure 2, my Lord.
Whom is it?
In arbitration case, my Lord.
Page
Page 50, my Lord.
Appeal petition the deputy commissioner so and to submit parawise comments on the matter within 7 days to the commissioner.
Second paragraph, my Lord.
Now the commissioner come arbitrator,
Yes, my Lord.
Central Assam Division, Nagaon, Camp, Guwahati
Yes, my Lord.
is no longer there.
Yes, Lord.
No longer there.
No, Lord.
Now who appoint?
That is appointed by the Ministry of Road Transport and Highways.
Who appears? Who appears for the Union of India?
Lordship, we are.
Then why you are not doing it by yourself?
No, Lordship, that appointment was given to that, in this case, Lordship, the commissioner come arbitrator central Assam division.
Understood.
was
Now that division is not there.
Not there.
Appoint somebody else.
Lordship, that process is, Lordship, going on, Lordship. But
Well-
due to that dependency of that interim order, Lordship, our total project works has been solved, my lord.
Ours means
National
Ministry
Highway-
of,
National
no,
Highway.
no, you are not national. National highway is he.
Lordship, this case is
No,
filed by the
NSADCL.
NHIDCL, my lord.
I am,
For whom you are representing.
I am an NSAI, that arbitration proceeding, my name was there, that is a made it party, directly not against me. Practice dismissal arbitrator,
No, this is being filed by Ministry of Mott.
that is by,
If it is Mott who is
NSADCL.
going to fix it,
Lordship,
why the Mott is
Lordship,
not doing all these
Lordship,
things?
that,
You,
arbitrator,
the
Lordship,
Mott wants,
Lordship, arbitrator was appointed by the Ministry of Law.
so appoint another one.
Thereafter, Lordship, by virtue of cabinet decision, Lordship,
Understood, they have removed the divisional power.
Yes,
No
sir.
problem. Are you not supposed to appoint another person? The authority is absolutely yours. Kindly see 3G. It is absolutely your authority to do so. Why should this court interfere or say anything out here? Where
in
is the
this
text?
case, Lordship, my prayer is only, Lordship.
No,
to
no, your
say-
prayer is, oh, let us
Status
not.
in that
No, no,
interim
no.
order.
First of all, you see, kindly see. 3G5 to be appointed by the central government.
Yes, Lordship.
Then why you are not appointing another person? Appoint anybody. You want suggestions? Appoint. What is this, all these things? You have the absolute power to appoint. Appoint.
Lordship, we have already appointed, Lordship. but,
Very well. I understand you initially appointed the divisional forester. What is your what is your problem in appointing an arbitrator in view? Then appoint. You want to leave, or should I make an observation that they have a petition and that this is the problem which is being faced? So the ministry, the petitioner would take appropriate steps for appointing the arbitrator at the forum. The petitioner is coming for appointment. My goodness. Who has the authority? It is something like the Chief Justice who has the power to appoint an arbitrator. Then the Chief Justice comes out there, appoint an arbitrator under 226.
Will take time, my lord, but the question is, Lordship, due to
No,
pandemic.
no, tell me, what can this court do? You want that the National Highway Act to be amended by this court? Or you want this order to be set aside?
Lordship, order passed by the earlier arbitrator, my lord.
To be set aside. For that, who should have come? Who is constructing?
We are constructing by
Who? Who is
National
we?
Highways Infrastructure Development.
No,
Board,
who is we?
NHADCL.
NHIDCL, my lord.
NHI. So NHI DCL ought to have come.
Yes.
Why have you involved the appointing authority? The Union of India?
NHIDCL is under the Union of India, Minister of Road Transport and Highways. That is the
So? But the appointment is to be made by the central government. They have removed that post, no problem. Appoint somebody else.
Lordship, our grievances, Lordship, after abolition, Lordship, government has given the charge to Commissioner General Administration Department. Now he's under the charge of these cases, mine. And we have filed one application also before him to vacate or modify that order. He is keeping the matter pending, mine. And that is
Tell
why,
me
Lordship-
that. Where,
Yes, mine.
where is that? To set aside the ex parte impugn order dated so and so. This court would not do it. You have a right to file an appeal. Why you're not filing an appeal? Have you seen the provisions about the section 3G6? What does it say?
subject to provisions of the, all provisions of the Arbitration and Conciliation Act shall apply to every arbitration under the case law.
So should I now give you a suggestion out here, sitting out here as a judge?
There's provisions
That section 37 applies?
37 or 30.
Why are you not doing it? And moving out here? How do you take care of section 5 of the limited of the Arbitration Act?
CG5, man.
Section 5 of the Arbitration and Conciliation Act?
Yes, man.
You leave this court with no option. You see, the problem what is there? Here, the appointing authority is seeking a direction from this court to an authority who has no authority. The state has no business. So that authority which has no business appoints another authority to take care of a situation which you ought to have done. Isn't it, Mr. Talukar?
Lordship, maybe taken up on Monday.
What do you say, Mr.
Yes,
NHI?
my lord, that is
Uh-huh.
now we actually, I'm also part of NSA as well. This I'm submitting. Why?
Isn't that the thing?
No, why this has come, my lord? What because only
No,
because
I have understood
that
that day also that matter. I have
yes,
yes.
chief given
Yes.
observation also.
yes,
We are having difficulties on this point.
I've given.
Now, my lord, of course.
No, it is you they who have appointed.
Yes,
Just for example, tomorrow, are you going to ask the state government that appoint somebody as a deputy commissioner here so that we can issue a notification under section 3A, small a, of the National Highways Act as the competent authority? Are you going to do that? Are you not asking the same thing? Then
yeah, that comes from.
so what to do?
Lordship may be taken up on Monday, Lord. Call up the instruction.
Huh?
What is the process going on regarding appointment of arbitration, Lordship? On Monday, my lord.
Monday morning, I will- Yeah,
Wednesday.
Wednesday.
It will again come back to me. At the request of the learned counsel for the petitioner, matter stands adjourned till Wednesday.
Wednesday, my lord.
54 and 55 sample.
No, 56. Sorry. I know 20. Order stay vacating.
My lord, in this matter, both the respondents have come up for vacation of the interim order passed about a year back.
Huh.
My prayer would be, my lord, instead of taking up the interim, if your lordship takes it up on a hearing day and the matter can be finally disposed of. Lordship, my prayer is the petition needs to be disposed of first.
Where is it?
Uh,
Where is the interim order passed?
my may be taken, IAS
No,
179.
it's okay, since however, the copy.
Demolition notice has been
Having
stayed.
it is hereby where the operation of the interim notice shall remain suspended. What is this notice?
Demolition notice
Demolishing notice.
by the GMD.
Page,
Page 107 of the report.
it's a show cause or demolition notice.
Demolition one.
No, it's a show cause only.
But it says
show cause, but in essence, it is,
Is a show cause notice?
in essence, it is saying that you remove
Now
it.
therefore you are directed on under so and so to stop construction henceforth and reply to a show cause. Why should this court at all interfere with all these things?
That is the problem. They are hand in glove with the private respondent. The issue that is, if your lordship will just,
You have submitted your reply,
yes,
show cause reply you have given, then what happened?
they were literally threatening to demolish it. And that is when we were compelled to approach this honorable court.
Oh, they will pass an order. Are you not going to go into pass an
No
order?
order has been passed. Before passing an order, they have approached the.
So then, what is there? Premature, premature.
If I, but,
Why should this court adjudicate when you have submitted your reply?
to that extent, I'm absolutely with your lordship. But the stage at which we were compelled to come is, they were literally on our heads to, and if I take your lordship.
I can only give you one thing at best. Is that if they pass an order, they will give you 20 or 25 days for taking appropriate steps for redressal of your grievance. That's,
That will happen.
that is the only thing, nothing more than that.
But they have said that they will demolish without further notice. That is why we were.
And they won't. They will go, they are, Mr. Bora, you are going to, you have to pass an order. Because without passing an order, you can't do that.
You have to pass an order because you have not applied the mind. Because applying the mind.
Understood, understood. So you will pass an order, and if you pass an order which will be prejudicial to the petitioner, then give him some breathing space for approaching the appropriate forum for 30 days or 15 days.
That will take care.
Lords will take up the section 71 of the, there is the appeal provision in the GMC.
I am not saying for moving the right to writ court. Let them move the appellate provision or whatever may be there for redressal. Once you come up, once you pass the order, you might pass the order at evening 4:30 and come up with the bulldozer at 9 o'clock.
That is what is happening. That is the problem.
They have 30 days time to appeal also.
And that is why that within this appellate period, you won't do anything. That's all.
That takes care.
See? Why should we have it for hearing on a particular thing?
This really takes care of my main problem. They were
Because otherwise I can't adjudicate. No, Mr. Chaudhary, I can't adjudicate what is given here.
True.
It won't be proper on my part when the authority is there to decide on. The instant writ petition is being filed, challenging the show cause notice issued by the Chief Executive Officer, Guwahati Metropolitan Development Authority. Alleging carrying out of unauthorized construction in the integrated campus of the Games Village within the Guwahati metropolitan area covered by master plan and zoning regulations in the manner and at the place as specified in schedule without the requisite approval of the GMDA and thereby contravening the provisions of section 24 and 25 of the GMDA Act 1985. It appears from the records that pursuant to the said show cause notice, a detailed reply was submitted by the petitioner to the Chief Executive Officer, Guwahati Metropolitan Development Authority on 23/8/2022, stating inter alia that there was no contravention of the provisions of section 24 and 25 of the GMDA Act 1985, as well as also the provisions of section 87 and 88(1) of the GMDA Act. There is no contravention of 24 and 25 of the GMDA Act 1985, and the actions so proposed under section 87 and 88(1) by the GMDA was illegal. Thereupon, the petitioner apprehending that the respondent GMDA may at any time pass an order and without giving the petitioner an opportunity to avail his remedies available under law, who demolish the structures, have approached this court by filing the present writ petition. It reveals from the records that this court, by an order dated 31/8/2022, had issued notice, and the operation of the notice dated 16/8/2020 was stayed till the next returnable date. It further reveals from the records that some of the respondents have filed their replies, that the respondents have filed their, that the respondent number 2 and 3 had filed an affidavit in opposition. It is also seen that the Guwahati Metropolitan Development Authority, as well as one MS Simplex Infrastructure Limited, had also filed interlocutory applications seeking vacation of the order dated 31/8/2022. Next. I've heard the learned counsels for the parties and perused the materials on records. It reveals that the issuance of the show cause notice by the Chief Executive Officer, Guwahati Metropolitan Development Authority, dated 16/8/2020, cannot be called into question on the ground of jurisdiction, lack of jurisdiction. It also is seen that the petitioner had also, in reply to, had also submitted to the said jurisdiction by submitting the reply on 23/8/2022. However, the petitioner only apprehends that the respondent authorities may pass any orders and without providing the pass an orders which may be prejudicial to the petitioner and without providing any opportunity demolish the structures constructed by the petitioners. So, taking into account the above, this court disposes of the instant writ petition, giving the liberty to the the Guwahati Metropolitan Development Authority to bring the proceedings initiated on the basis of the show cause notice dated 16/8/2020 to a logical conclusion. This court further observes and directs that in case such orders are passed which are prejudicial to the interest of the petitioner, then a period of 1 month be provided to the petitioner from the date of service of the order, so that the petitioner may avail such remedies as available under law.
But my lord, we may also be given an opportunity to file a representation before the authority. my lord.
You want to participate?
Yes, my lord.
This
Respondent
no,
number.
no, but
four.
but as regard that, would it be proper on your part, because you have no
Also there,
business.
it's okay, my lord.
In fact, you being involved out there would show some malafide.
That is why I have kept quiet.
Other IA stands disposed in view of this.
Deeply obliged.
Right.
My lord, this stay order will be operative for 30 days.
I've said go with it.
Yes.
There's no stay order.
For
as of
30
now.
days,
No, when you have not passed an order, where is the stay order? If
no,
you
my lord,
pass an
the
order,
interim order was there of the
no, there's no interim order was the stay of the notice.
notice. Now they will.
No.
provide with-
I have asked them to bring to a logical conclusion that notice initiation.
In a period of
And
30 days.
no, whenever they feel like. But if they take any action or any pass an order which is prejudicial to the interest of the petitioner, then 30 days time be given from the date of delivery of the order.
21. 30 days. 30 days. My lord, there is one problem because now our part of the new construction is almost over. So my lord will give the GMD time frame
To finish the
finish the hearing.
No, the problem, that problem is, you see, how can I direct the GMDA to give a time frame? Because he is only to decide that. Why should I give a time frame to them?
Decision, there is a
No,
provision
If they, if the GMDA has no control over his officers, then it will look.
21, order no step.
No, Ricky Metail.
No step.
Order? ಇದು ಏನಕ್ಕೆ ಒಪ್ಪಿಸ್ಬೇಕು?
Yeah, those cases, my lord. Simply, my lord, the pitch.
No steps.
No step.
Order no steps. And who is appearing?
I appear for this, my lord, I am part in.
এই মই এটা order pass কৰিছিলো বুজিছেনে? এইটো it seems that they have not been informed and as such registry is
Exactly.
directed to inform. পাইছেনে এইটো? এইটোতো এনেকুৱা order এটা দি দিব to be listed after 4 weeks. Huh? এইটো বহুত
Same, my lord, it is same.
Same.
I think so, my lord. National NHPC only.
Same.
Much
thing. 22 একেই নহয়? খালি একেটাৰ নামটো দি দিব হা বিডি গোস্বামী এডিশনাল
23 for admission.
Lordship, my senior is election, court number 12.
Huh?
Kindly pass out the matter for time being.
Oh, this matter. The 10,000.
Yes, my lord, on the last occasion, my lord has.
Yes, Mr. Advocate General,
I was in
for this
another court. In that
10,000 you
case,
are running.
Other previous case, Lordship,
Yes. Tell
my
me.
name may be recorded not for any other purpose because
No, no, the names, I don't record anybody's name. I put everybody, give the discretion to all the lawyers to put whatever names
no,
I
no,
just
it is
put
not
on
that,
top.
Lordship. There is some other reasons because there
I
are some
put it.
issues here. That's why.
No, I put the names. has
Somebody
to be-
complained I
he
don't
may
appear
very
in
well
this
be-
case.
Because I don't record. In my orders
It's okay.
nowadays, you don't find anything.
Perfect, Lord.
Your name will be put like this here.
Yeah.
So that will be there. Don't worry. Just ask him to put the name.
Highly obliged, Lord.
So there I have given the GMDA to bring it to a logical conclusion. I have not given any time for that. But if they take any action against the petitioners or any prejudicial, 30 days time may be given for redress.
So that
That's
means that wall is there. We have to break it. Actually, we have given them the notice,
understood.
and that has
That
stalled
is
the
why
whole
it has been,
project last 1 year.
yes, it has been stayed out there.
Yes, Lord.
So better off you take a decision. He has already, I have not given anything for any hearing or any personal hearing, nothing. You bring it to your logical conclusion.
As per the provisions of the statutes and the rules.
Do whatever, why should I say?
Highly obliged.
দুটা বাজিল না?
Yes, Lordship. This writ petition is preferred by the state Lordship, whereby we have challenged the order of the order dated Lordship by the Assam Human Rights Commission Lordship. This is order dated 22/11/2012 Lordship, whereby we have been directed to make a compensation of rupees 3 lakhs, as because the findings was that the person was detained illegally. The person, Lordship, he was a life convict. If your Lordship goes by the annexure 2 at page 18, this is the chronological dates, Lordship. On 2 has your Lordship got it, page 18.
At page 20, Lordship, this is the date taken by the Human Rights Commission, that is
Now that I have looked into.
Lordship.
Now tell me. He was a life convict.
Lordship.
Let's come to page 28.
Page, Lordship,
28.
20. Yes, Lordship. This is the rules of management of jail in Assam, Lordship. That is release of life convict. Serial number 4. May I read, Lordship? The superintendent shall submit to the Inspector General for every half year ending 30th of June / 31st of December, that is a half year, the following in duplicate in respect of any life convict who has completed as on 30th of June, 31st of December, as is due to complete within the next quarter, 20 years imprisonment, including any remission earned under the rules. Descriptive role, report as to the life convict's conduct and performance in prison, and remarks as to his fitness for release. The Inspector General shall thereupon send his recommendations to the appropriate government, who will communicate the order remitting or refusing the life sentence to the Inspector General for transmission to the superintendent. If the life sentence is remitted, the superintendent shall release the life convict as such date as may be specified in the order. If your lordships then come to the page, last page, page 33. This is the order from the government.
But there was a delay of 5 days.
Lordship. That letter was issued on 22nd, 23rd from Annexure 2, page 18. It reflects that that letter was received on 23rd of March, first, second, third, fourth line. Then 24th was a holiday. It was a fourth Saturday, 25th Sunday. On 26th, file processed by the office. But if your lordships go by that sections 432 CRPC, because under that section, this provision of remission is there.
Are you saying that the Assam Jail Manual needs to be modified?
Yes, they are also following this 432.
No. Are you saying that the Assam Jail Manual is wrong?
No.
It says that it has to be on that day itself.
As mentioned.
In that order.
Yes.
And the order says on with immediate effect.
With immediate effect.
Well,
but it doesn't
immediate
mean-
effect means immediate.
No, yes, immediately.
Thereafter, wouldn't it be illegal detention?
No,
Yeah.
it cannot be.
Why?
As because it's a life sentence, lordship. Life sentence means life. 432 says that life sentence, it should not be less than 14 years. So it should be more than 14 years. It can be 14, 15, 16, 17. But in jail manual, it is stated that 20 years is also there. So 21 years can also be there. There is no such illegal detention, lordship. I am relying on a judgment on that line, lordship.
No, there is no illegal detention means the moment the order has been passed. I'm not saying earlier period. The moment the order has been passed, can you say where it says in the manual of if the life sentence is remitted, the judge shall release the year on as such date as may be specified in the order.
Yes.
Then-
As maybe
Why didn't you release
that is
then?
with immediate effect. Immediate effect means
Means immediate on that date.
immediate on that lordship there. Because of this technicalities, we cannot.
Why?
We
What
are
is the
unable to.
technicality?
Your lordship may kindly come to that annexure 2, page 18.
Page?
Page 18.
Yes.
That is the fourth.
Are you saying that,
23rd
are you saying that if a person completes his period on a Saturday or Sunday, he can never be released? Or on a public holiday, it can't be released? Is it your statement?
From the record, it reflects like.
No, is it? That has to be a contention on your part.
Yes, Lordship.
Then show me.
The government order.
No, then obviously there will be something on record, something that even on a date of the release, if it is on a Saturday or Sunday, our convict cannot be released. Show me that.
Lordship, when Lordship, it's a fourth Saturday, it's a holiday, then it's a Sunday.
I'm not on that. I'm saying, let us assume that the order has been passed or a person completes
Yes.
7 years in imprisonment. There's no remission. Forget about any remission.
Yes.
But he completes on 15th of August. He can't be released.
I have to see, Lord. I have to see.
Because then the moment the order, because the genuine manual says as on such
But
date
yeah,
as
but
may
in
be given.
Some cases, Lordship, we have found that when we get the bail order from this honorable court, next day is a Saturday, then Sunday, that person, we are able to place that bail order on Monday. On Monday, he was released.
Understood. But has he raised any issue on that? If he raises an issue, that's a different question.
I have to see in that line, Lordship.
I'm not in agreement with the Assam Human Rights Commission as regards the delay of 40 days. No, I'm not on that because that may take some administrative exigencies to the effect. But the moment the order has been passed to be released with immediate effect, then he
Immediate
has.
effect, Lordship.
Immediate effect
immediate-
means immediate. On that date.
In my opinion, Lordship, immediately on the very opening day, Lordship. When after processing all these things, they have not delayed, Lordship.
They have not mentioned the words that immediately after processing the papers. No.
No, that immediate word is.
Then the order becomes useless because there after that a person
Had
may
there-
take
had
2
there
months.
been any deliberate delay, Lordship, it would
No,
have been.
there is a deliberate delay. Why couldn't you do it? It's a person's liberty is the question. We are concerned with the liberty.
That is when-
Once the remission has been granted, a right is conferred upon him. Thereafter, any day thereafter
Yes, had
has
it
to be
been-
taken
had it
into
been in
account.
other cases, Lordship, that punishment is for 7 years.
Forget about when any other case, the moment he has been granted the thereafter keeping him inside has to be on the basis of some order passed by the court. You can't put him inside one that in view of the jail manual, unless you say that the jail manual is contrary to the provisions of law.
My submission is that, Lordship, had there been any deliberate delay,
No, deliberate means, are you saying that on Saturday, Sunday, you are not going to do work?
that I have to look into, Lord.
No.
I don't have that
It's a
knowledge.
very
In
serious
that
thing.
line, Lord.
If it is so. Because every day is a 1 day extra is, you may think, well, oh, this fellow has been there for 12 years. What is there? One more extra day.
No, Lordship, illegal detention is illegal detention. I also
That is,
admit
the
that.
moment he has been asked to be released with immediate effect, he has to be released on that date.
Lordship.
Or at best, if the order has been reached, the superintendent of police on the next date, then on that date.
No, Lordship,
Not
maybe
anything
some-
else.
I have to obtain instructions in that regard.
What is
Because,
there? That
Lordship,
is the
some
point of law. What is this
procedural-
instruction business out there?
No, Lordship, I do not have that knowledge, Lordship, whether on that holidays, these things can be done or not. I personally, I do not have any knowledge of. So I do not want to make submission on that, Lordship. May I get some feedback, Lordship, in that? In that case, Lordship, I can place before your Lord. If it is wrong, it's wrong. Lordship.
Office holiday due to 4th Saturday. Right? How can it be?
No, certain procedures
Office
are there,
holiday due
Lordship.
to Sunday. File processed by the office and the Inspector General of Prisons approved.
As because it is to be sent to the from the Jain mail when it reflects that this order is to be sent to the Inspector General of Prison. So
No,
it is
from the Jain manual, it goes from the superintendent who for the last
no,
quarter.
approval.
No.
Lordship.
It says that in the last quarter, in the if a person in the next coming quarter is going to complete 20 years, then falling on 30th of June or 31st of December, the recommendation has to be made. And that recommendation will go to the IG. Now here everything has happened.
Lordship.
Are you saying that after the governor's order, it has to go again to the IG? No.
Lordship, the Inspector General shall thereupon send his recommendations to the appropriate government.
The appropriate
Who
government
will-
is the,
Yes. Who will communicate the order remitting or refusing the life sentence to the Inspector General again?
so that's it. Now,
Yes.
the,
Then
it has
Inspector
been
General
received.
sends it to the Superintendent.
Whether the government, the order was passed on 23/3/2012.
Well,
And then this order has been made copied to the Inspector General of Prisons.
yes.
So this means it has been duly received, it
Then
will be deemed that
Inspector
it has been
General-
received.
Inspector General for transmission to the superintendent.
Yes. So then, you see, kindly see at page 33, the order says it is copied to the Inspector General of
Yes.
Prisons with reference to the letter dated so-and-so, the superintendent of so-and-so jail for necessary information. And this was duly received. And your
Yes, yes.
list of dates at Annexure 2 does not say anything when the Inspector of General of Police have received it.
No, on 23rd, Lordship.
So if he has received it, no,
Then on 24th,
was received in the by the IG prisons.
Yes.
So on 23rd,
yes.
on that very day, on 22nd, on the next day. So on that day, he ought to have been released.
No, Lordship, there may be some procedure I have to.
The
a person-
procedure, if it is there,
that
burn
is the
your midnight.
earliest possible
No,
day,
Mr. Sharma, if there is a procedure, you have to burn the midnight oil and complete the procedure because it is a case of liberty.
I have to take in I have to,
When?
not Monday, Lordship, let it be on.
We may increase the amount. We may increase the amount of 3 lakhs. Because for us, 3 lakhs is 2 lakhs for five
That
days.
is a different aspect, but Lordship, your Lordship,
No, it is a serious thing. 5 days illegal detention is a huge amount. For the Assam Human Rights Commission, they must have thought about 40 days to be 3 lakhs. But for me, a person's illegal detention for 5 days may quantify to around 30 lakhs.
our public money, Lord.
Public
Lord.
money,
Our money, Lordship.
no
Your-
problem. Take it from the pension.
I leave it to your Lord.
Take it from the pension
But
of
let
those
me get that
officials.
regarding the compensation part, Lordship, it's up.
Because
to
you
your-
have filed out here only on the basis of the compensation. What is the problem with that order then? You have only challenged this order on the basis of compensation.
Lordship, we have also challenged an order of the Human Rights Commission, which is not in accordance with law. Lordship. That is also the case.
Under why? The award has been passed of a 3 lakh amount.
That amount is not very much important, Lordship.
Very
If
well,
they-
then pay that amount. Disburse
Okay,
it,
that-
we'll have
if
it on the
your
next
Lordship
date.
directs, we must have to follow.
No,
We
no,
must have to follow.
no, if that is not the issue, we'll record it, pay the amount to him. Then we'll consider the remaining amount. If any other amount is directed.
Let me get my instructions regarding that.
And
immediately.
get hold of the person who were the Inspector General of Prisons then and the Superintendent of area on that day, because we'll issue notice to them. Because without hearing them, it may not be proper to impose that amount should be taken from their salary or pensionary benefits. Get hold of the names. List the matter when?
Let it be on Wednesday, Lord.
List the matter on 29/2023.
29.
29. On which date Mr. Sharma shall apprise this court as to whether after receiving the order dated 23/3/2012, 22/3/2012, on 23/3/2012, by the IG prisons as well as by the concerned superintendent, would it not amount to illegal detention to release the convict on 28/3/2012? The taking into account that the amount of rupees 3 lakhs have been burdened upon the state on account of the laxity on the part of the Inspector General of the then Inspector General of Police, prisons, as well as the Superintendent of Jail. The Mr. H. Sharma shall also provide the names of the said personnel who were holding the post at that relevant point of time on the next date. List accordingly.
20th of September, Lord.
20. You want it before?
Lord. Must have been.
Number 23 for admission.
Yes.
My lord, the subject matter has already been decided by the coordinate bench of our High Court, my lord. If your lordship permit me, I can supply.
Giving this 10,000. Oh, they had this problem now. Where is the Mr. Arbor Pujari
Today I met him in the morning hours.
and Mr. N.K. Devnath?
The subject matter has already been decided, my lord. Lordship will see at operative part of the para, my lord. See.
Mr. Hendrik, you are appearing here. And Ms. Bora? There's a judgment passed by a coordinate bench in this matter. Huh? You leave it to me. Because on that day, your colleague in the same department was fighting tooth and nail. Yes, Mr. Barbagari. A similar order has been passed by a coordinate bench.
Same thing. Same subject. It is the right to come to. Same stand was also taken, my lord. They said in the after going through the judgment, I came to know, my lord. They said same thing that has been withdrawn, cancelled, this thing, that thing. But here is the, my lord, case identical and similar, same team.
No.
Finance has
That
already,
direction is already there.
finance has already filed
Subsequent-
affidavit stating
Huh?
that, my lord. When they approach, they will give, my lord. It is clear, my lord, para 3 of affidavit, my lord, of finance. Liberty to move the finance budget report to make supplementary demand provision of the equivalent amount to the strictly as per the need. Once the amount capped in the revenue department is surrendered to the state exchequer with this transfer.
Rakho. The instant writ petition has been filed by the petitioners. Seeking a direction, seeking inter alia for a direction to provide the remaining benefit of rupees 10,000 to each of the petitioners in respect to the CM special scheme financial assistance for construction of 126,000 dwelling houses for homeless people. From a perusal of the materials on record, it reveals that pursuant to a notification dated 30/10/2015, it will be revealed that the Secretary to the Government of Assam, Panchayat and Rural Development Department had issued a notification on 30/10/2015, whereby an amount of rupees 25,000 each was to be disbursed to 800 numbers of beneficiaries from general category and 200 numbers for minority community for the year 2015-16 in respect to a scheme that is CM Special Scheme Financial Assistance for Construction of 126,000 dwelling houses for homeless people. The petitioners herein have already received 15,000 out of the said amount of 25,000. The petitioner herein are aggrieved on account of the non-payment of the non-releasing oblique disbursement of the remaining amount of rupees 10 lakhs, 10,000 each to each of 10,000 to each of the petitioners. It reveals from the records that this court, by an order dated 9/12/2016, had issued notice making it returnable by 5 weeks. The records further show that the respondent number 4, that is the Chief Executive Officer, working in the office of the Commissioner, Panchayat and Rural Development Department, had filed an affidavit in opposition. In the said affidavit in opposition, it was mentioned that the government in the finance department, by an order dated 7/10/2016, had directed to deposit back the unutilized fund lying with the DRDA, as well as the blocks under the CM special scheme for the year 2015-16 immediately into the treasury head of account bracket 0070-60-8000 bracket close by 31st of December 2016. It is in terms with the said order of the finance department that all BDOs deposited the unutilized fund into the Treasury Office. It was further mentioned that the special package was taken up for the financial year 2015-16, and the aforesaid scheme was not a continuous scheme, and the period of implementation of the scheme was already over in the year 2016. It was all, further to that, it is mentioned that the schemes have already been closed by the department and those were replaced by the new central government scheme, namely PMA-Y scheme. This court further finds it relevant to take note of the affidavit filed by the Finance Department of the Government of Assam through the Deputy Secretary to the Government of Assam Finance Budget Department. In the said affidavit, so filed by the Finance Department, it was mentioned that the administrative department were authorized to withdraw the entire fund kept in the revenue deposit and deposit the same in the state exchequer under appropriate relevant heads of account within 14/8/2015 positively, and the concerned administrative department would be at liberty to move the finance budget department to make supplementary demand provision for an equivalent amount strictly as per need, once the amount kept in the revenue deposit is surrendered to the state exchequer, which was issued wide OM number b dot 191/2013/55 dated 10/8/2015. It was mentioned that the administrative departments were requested to submit the necessary proposal for incorporating in the budget estimate for 2016-17 for the amount refunded of all unspent amount released in 2015-16 from the revenue/civil deposit to the state exchequer, which was issued by letter number BB dot 191/2013/68 dated 1/7/2016. Further to that, it was mentioned that in spite of the said instructions, in some departments, substantial amount related to state plan schemes were still lying in the accounts of the DDOs of the societies. Therefore, all administrative departments were again requested to deposit all amounts unutilized and drawn under the state plan scheme of 2015-16 and utilized till 31/3/2016 into the state exchequer immediately, which was issued by WT message dated 7/10/2016. This court have also heard the learned counsels for the parties. Mr. J.L. Borbunya, the learned counsel appearing on behalf of the petitioner, had further submitted that similar issues also arose for consideration before a coordinate bench of this court in the case of Rahim Uddin Loskar and 41 others. Dated 26/4/2019, wherein Rahimuddin Losko and 41 others versus State of Assam. State of Assam, bracket or WPC number 5563/2016, dated, bracket closed, dated 26/4/2019, whereby the coordinate bench of this court held that there is no denial to the effect that the petitioners were amongst the selected beneficiaries of the scheme in question. Petitioners therein. And it was only due to certain technical reasons that the matter of release of the disbursement of the amount to the petitioners were delayed. The court and bench further opined that since the petitioners are amongst the selected beneficiaries, denying them the benefit would amount to discrimination vis-a-vis other beneficiaries, as technical reasons in the form of discrepancies in the bank account should not come in the way of disbursement of the amount which is for public purpose. Accordingly, the coordinate bench of this court had, while allowing the said petition, directed the finance department to make available the amount in question, which was refunded by the parent department as unutilized funds. The parent department, that is the PNRD department, was further directed to take steps to release the amount in question to the petitioners respectively after proper identification. The entire exercise was directed to be completed within a period of 3 months from the date of the said order. This court, upon perusal of the material of the said judgment, is also of the opinion that the petitioners in the instant writ proceedings are similarly situated. There is also no denial to the effect that the petitioners herein were not the selected beneficiaries. Under such circumstances, in the opinion of this court also, the petitioners would be entitled to the remaining amount of rupees 10,000 each in respect to the scheme in question. This court further finds it relevant, this court further finds it relevant to take note of the submission of Mr. R. Borpujari, the learned counsel, appearing on behalf of the finance department, who submits that in order that submits that for an effective compliance to the order, a direction should also be issued to the PNRD department so that they may place the relevant materials, including the names of the beneficiaries, which would enable the finance department to pass necessary sanctions for disbursal of the amount to the petitioners through the PNRD department. This court finds that the said submission to be a fair submission, taking into account the complexities which would otherwise be involved, taking into account that the scheme had already been closed. Under such circumstances, this court therefore disposes of the instant writ petition with a direction to the Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department to forward the details of the petitioners along with what? Earlier utilizations. But would that be there now? If that is given, then you will take the handle, no?
That may not be given, my lord. It's a small amount BPL person, my lord.
I understand that. And that is why, along with documents showing that the petitioners herein have already been disbursed the amount of rupees 15,000. Upon receipt of the said details from the Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department, the Finance Department of the Government of Assam and more particularly, the Commissioner and Secretary, Finance Department shall take necessary steps so that the sanctions necessary sanctions are issued, which would in turn enable the Commissioner and Secretary, Panchayat and Rural Development Department to disburse the amount of rupees 10,000 each to the petitioners. The said be done within a period of 3 months from the date a certified copy of the instant order is served upon the Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department, as well as the Commissioner and Secretary to the Government of Assam Finance Department.
Production list, item number 1 for motion.
All are same.
My lord, all are same lordship in this case. Lordship, the petitioner has been residing his residential premises at his own patta land, lordship. Now kindly see lordship.
Wait,
the
wait,
notice
wait,
on-
wait.
My lord,
Hey,
here is
baki kita
petition.
putih kita.
My lord, at page 16.
Page 12.
My lord, annexer 2, page 12 is the patta. Jamabandi lordship, this is in my name lordship.
Page 12 is the patta.
Sorry.
Where is the
annexer one-
patta?
15, page 15.
Putih kita dia. Okay. All are same. All are same.
All are same lordship, different
Got it.
persons. My lord, different pattas. All
Okay.
are patta holders. lordship.
Where are the pattas?
Patta is lordship at page 15 lordship.
Page
This is the
15?
Jamabandi.
Page
Jamabandi
15 is
copy,
the
my lord,
Jamabandi.
my lord, the type
Page
copy
12 is
at
the
page
patta.
12 lot.
Where is the patta?
Page 12, this is the Jamabandi. Patta is not, this is paternal property, right of inheritance lordship.
It's a Jamabandi.
Yes, lordship.
Okay, then.
My lord, page 16 kindly see a notice was issued certainly on, my lord, 2/9/2023. It was served on, my lord, 3rd of September. My lord, saying that I am, my lord, possessing, my lord, government land, giving a particular, my lord, tag number, lordship. And I have been asked to, my lord, vacate the land, lordship. My lord, thereafter, that is.
So you are saying that you are in Pattaland.
Yes, lordship. My lord, then,
Fantastic.
my lord, I submitted a report.
So your thing can be protected.
Yes, lordship. My lord,
Thereby the revenue authority shall verify as to whether the land where you are standing is a patta land or land comes under 628/419.
yes, lordship.
If it is comes under 628/419, this court would not touch it. But if the land is otherwise revenue land or your patta land,
Yes.
the authority shall not do it.
My lord, I submit, kindly see for the timing, my lord.
Interest, Mr.
Page 18, lordship.
Huh?
Page 18, lordship. I submitted an application also, lordship, saying that we are residing in patta land, lordship. We are not occupying any government land, lordship. Even then insisting to vacate the land now, saying that no, that land is required.
Okay, very well. Then, yes, I've understood your point. Your petition is otherwise so short,
Lordship, yes.
15, 16
RAC,
pages.
lordship,
Yes.
it was
yeah.
cleared.
Yes. That is what I'm saying. If he is my only, this court is going to dispose of these matters. This court need not keep it. Here, if it is in patta land, the revenue officials shall verify. If it is in the patta land out there with the Lat Mandal, you can't touch it. But if it is not, then that is your lookout.
My lord, I would not come before your lordship, lordship. My lord, in the notice, it is specifically stated that to remove my house, lordship.
Understood.
problem.
Everything will be removed if you are in the government land. Oh.
We specifically stated in the representation. I specifically stated in the representation that we are.
No, Mr.
Yes, Lord.
Mr. Counsel, Mr. Ahmed,
Lord.
you will be protected in respect to your land,
Lord.
but
That
you
is my
would not be protected in respect to others.
Government land, I don't want protection in government land.
So we dispose of.
Lord.
এটা মই জাজমেন্ট লিখি দিম, বাইকিটা আপুনি কৰি দিব। I mean, ডাক নম্বৰটো খালি বদলাই দিওঁ, বেলেগ একো লিখিব নালাগে। হ'ব? Sure. All facts must be same.
Lordship, yes.
Annexures will be the
Yes,
same.
Lordship,
Only the
different
tag numbers will be
tag
different.
number and patta numbers different. Area of land different. Lordship.
Okay. Now ask your learned juniors
My lord.
to give the list wherein, in which case, which patta number.
Yes, I'll provide it. Yeah, that was purchased agreement is there. Other people, man, it is it
No,
is
no,
also
whatever may be, you see, if it is not a government land, you cannot maintain.
Lord.
So you will constrict yourself to the schedule mentioned in your notes.
Lord.
Oblique 419. A Pondua number 2, Borsola map under Novospia Moza. That's all.
Yeah.
And why they have strike off 628? Kindly come to annexure 2.
My lord, in item number 1, Lordship.
Yes, yes. Why 628 has been struck off?
My lord, 628, this is my lord, it was, my lord, two numbers is there.
It's not,
628. I don't know why it is 628.
No, no, it seems to be a struck off, or is it
It should
something
be-
which has happened?
it
Because
should be
here
in
they
the
have struck
original-
off.
in the
You see,
particular, my lord, it was
Novosia,
struck off, Lord. By mistake,
now Besa,
it was struck off.
Moza. Then
628 was struck off.
another thing is Pandua. Pandua has been Pandua has been struck off.
Number 2 also.
No, Mr. Borbuzari, isn't this striking out of the name of this Pandua? No, Pandua is struck off.
Struck off, Lord. In the vernacular, it is struck off. Lord.
Why? That is why this is relevant, na?
Lord.
Ah. And why have you written in this letter? What is your patta number?
My lord, patta number 1 is my lord, Miyadi
Patta
patta
is
number
50. 50 and 211.
211 new null. It was
221.
converted to 221. And that number 624. First one, Lord.
The instant repetition is being filed by the petitioner. Seeking a direction and seeking a writ in the nature of certiorari for setting aside the eviction notice dated 2/9/2023 issued by the Circle Officer Novosia Revenue Circle.
Now, boy, Lord.
As well as also seeking a direction, writ of mandamus, directing the respondents not to evict the petitioners from their own patta land under Miyadi covered by patta land, covered by your patta land is 2 bighas 1 katha.
And
3
item
bighas 1
my lord,
katha.
3 bighas 1 katha.
Patta land, admeasuring 3 bighas 1 katha 0 lesser, covered by dark number 624, of periodic patta number 50 old oblique 221 new. Full stop. Taking into account the issue involved, this court and issue involved, and the respondents are duly represented, the instant court, this court proposes to dispose of the instant writ petition at the motion stage. The case of the petitioner hearing is that the petitioner is the owner of a plot of land measuring 3 bighas, 1 katha, 0 lesser, covered by dag number 624 and included in periodic patta number 50 old oblique 221 new, situated at village number 2 Borhala under Moza Nobosia in the revenue circle Nobosia in the district of Lakhimpur, Assam. The said land, for the sake of convenience, is hereinafter referred to as the petitioner's land. It is the case of the petitioner that the petitioner that on 3/9/2023, a notice was issued under Rule 18(2) of the settlement rules framed under the Assam Land and Revenue Regulation like 1886. Was issued by the respondent number 3, asking the petitioner to remove his residential houses, ponds, etc. under his possession within 7 days. The said notice have been impugned in the instant proceedings. It is further appears from the records that the said notice have been enclosed as Annexure 2 to the writ petition. From a perusal of the said notice, it is seen that the land wherein the petitioner have been alleged to be in possession is a plot of land covered by dag number 628/419 of Pandua/number 2 Borhala map under Nobosia Musa. The petitioner immediately upon receipt of the said notice on 5/9/2023 informed the respondent number 3 that the petitioner is not occupying the land mentioned in the said notice. And in that regard, the petitioner also mentioned that the petitioner is in occupation of the petitioner's land. And for that purpose, enclosed the Jamabandi as a proof of the petitioner's ownership of the petitioner's land. It is the further case of the petitioners that in spite of the said representation so submitted, the respondent number 3 is going to evict the petitioner from the petitioner's land and for which the petitioner has approached this court by filing the instant writ petition. I've heard the learned counsels for the parties. Mr. R. Borputari, appearing on behalf of the Revenue Department of the Government of Assam, submits that the respondent authorities shall take action of eviction only in respect to the land mentioned in the notice and not any other land. He further submitted that it is not known why the petitioner have been issued the notice if the petitioner is not in occupation of the land mentioned in the schedule to the said notice. This aspect would require verification. Upon hearing the learned counsels for the parties, this court is of the opinion that if the land wherein the petitioner is possessing, that is the petitioner's land and not the government land, the petitioner cannot be evicted from the petitioner's land. However, if the petitioner is in occupation or possession of government lands by virtue of Rule 18(2) of the settlement rules, the deputy commissioner or his delegate, in terms with Rule 3, would have the power to evict any person residing over the government, possessing government lands. Under such circumstances, this court also, this court also takes due note of the submission of Mr. R. Borpuzari, the learned counsel appearing on behalf of the revenue respondents, who submits that the authorities be directed to verify before proceeding with the eviction as to whether the land presently in occupation of the petitioner is the petitioner's land or government land. Taking into account the above, this court therefore disposes of the instant writ petition, thereby directing the respondent authorities, more particularly the respondent number 2 and 3, not to evict the petitioner from the petitioner's land, the details of which have been mentioned herein above. However, if the petitioner is in possession of the land described in the schedule to the said notice, this court does not is not inclined to put an embargo upon the said respondent authorities from proceeding with the eviction. This court further directs the respondent number 2 and 3 prior to taking any further action on the basis of the impugned notice to verify as to whether the petitioner is in respect to the land, whether the petitioner is in occupation of the land of the petitioner's land, or in respect to the land mentioned in the notice. With the above, the instant petition sent disposed. Full stop. Mr. M. H. Ahmed, the learned counsel, appearing on behalf of the petitioner, submits that the 7 days period is expiring tomorrow, and as such, and it may not be possible to get an urgent certified copy today. This court directs the courtmaster of this court to provide a true copy of this order to Mr. M. H. Ahmed during the course of the day. Further to that, this court also directs Mr. R. Borpujari, the learned counsel appearing for the respondents, to apprise the respondent number 2 and 3 of the order so passed by this court today.
Hello.
No, I have already described it. Hereinafter referred to as the petitioner's land, I have already given. So that is why I am not saying. So wherever it is there on top, I have given.
All right,
So that is-
my lord. Only in item number 3, my lord, only in item number 3 and 5, lordship. That is, although the petitioner, my lord, has taken the land from the.
I'm not on that.
Patadar is different, lord. That is private land. Patadar is different. There is an agreement of, my lord, particular land. My lord, this is a.
You are in possession of,
Me, lord. Patta land,
you are in possession of some other patta land, not government land.
not government. That makes my.
So here 3 and 5 এটা কথা ক'ব লাগিব. The petitioner by the তাত লিখি এটাই লিখিব. Petitioner claims out here that by dint of an agreement with the owner of the patta land
Moinul Haq, lord.
is in possession of the land described, land measuring, at measuring so and so, এইখিনি দাগখিনি দি দিব, হা? এইখিনি দাগখিনি দি দিব, and hereinafter referred to as the petitioner's land. সেই ওপৰত এইখিনি লিখি দিব। And ইয়াতো সেই দাগ নম্বৰ কেইটা বদলি যাব।
Matam.
Separate over, all separate. You may go. And you see,
Hello, sir. I'll leave it to the Honorable Court, madam.
Yes, madam. Why shouldn't we call that person concerned to the court? There's a specific direction.
Yes, madam.
And you have made the use of the National Highways Act useless. Are you not the competent authority?
Yes, madam.
You are to fix. What is this asking about from the NHAI?
I fail to comprehend, madam, what this is about.
This court doesn't like the call for the competent authority, but now the competent authority has to be called. And I think an understanding has also to be given to the commissioner and secretary. They also should advise these officials properly. So best of, did you hold the conference for that? Or direct them to personally appear? Are these officials not aware of the provisions of the National Highway?
No, yes, it is there. I mean, in fact, my lord, item 26 of today's list, that is also similar matter, wherein my lord has directed us, my lord, to file an affidavit. Today morning, we have filed an affidavit. My lord, the affidavit, my lord, we have enclosed, my lord, in the award, which is a part of the writ petition, my lord, that award.
You are referring to which case?
Lordship, may kindly take up item 26 for a moment, my lord. That is where we have filed an affidavit. My lord, we have filed it today morning. Award here, লগাইছিলে নহয়? আপুনি নহয় জানো, অফিচজন দুইটা পিছতে?
Yes.
26 awardটো আপুনি ক'ত লগাইছিলে? Awardটো লগাইছিলে নহয়? Yes, yes. I put an order আছিলে, set for एक matter. কি লাগে? Item number 26 টো মই সমস্ত বস্তুখিনি পাইছো, মই কৰি আছো লাহে লাহে কৰিব লাগিব, মই কৰি আছো। That award, my lord, will kindly come to page 33. Item number 26.
Yes.
My lord, there were, my lord, three clear directions, my lord, from the arbitrator. So far as the first one, my lord, the value of land for the purpose of compensation are to be made, incorporating the solatium interest as well as additional compensation, whichever are applicable as stipulated by law as well as direction of the state government. This, the Kala has he is the revenue official. Second direction will kindly say, my lord, the valuation of the building has to be made as per prevailing market price as on date of taking over possession of land acquired which the building was standing. This direction also Kala will have to take. There is no escape. But the third direction, the valuation of trees has to be made by the competent department, forest or agriculture department as the case may be, as on date of taking over possession of land. The competent authority is directed to intimate the date of taking over possession of land to the concerning department. Accordingly, and pay compensation accordingly to such assessment, the appellant shall be at liberty to approach the arbitrator if they are aggrieved once the decision so and so. Now, my lord, the first, so far as the third direction is concerned, my lord, the competent authority in our affidavit, my lord, we have enclosed it, my lord, though it is not a part of the record today. My lord, that communications were made, my lord, to the forest department. My lord, on my lord, 28/12/2018, and prior to that also, my lord, to forest department as well as the my lord PWD authorities, because my lord, the valuation of building and all these things will have to be done with in consonance, my lord, with those departments, because they have the expertise. I can only.
Does it take 9 years?
No, that is true, my lord. That once that exercise was undertaken. Now, my lord, yesterday, my
You
lord,
are only to fix as per this, rightly or wrongly, whatever may be. If
No,
he's
it-
agreed to that effect, he can take action. But why you have not done it till now?
no, it has been done, but nothing is forthcoming from those departments. That
Not,
is-
I'm not concerned without now. If it doesn't come, you do whatever you like, but you have to comply with this.
No, I cannot, because of the reason, my lord, that the quantification will have to be done, my lord, in terms of the valuation, my lord, the criteria that has to be, my lord, provided by those departments. And my lord, Roche will kindly hear.
Yesterday evening, my lord, we have called this authority, my lord, ADC. ADC has come and my lord, he has, my lord, vetted that affidavit. Today morning it was called. Now, my lord, so far as this file is concerned, my lord, that has been misplaced, my lord, due to shifting of that office. So it is taking some time, my lord, to get the up-to-date instruction. Now, on the basis of
No,
the,
it will obviously get misplaced.
Yeah.
It will obviously, when you have taken for compliance of an order for so many years, 9 years, have you asked the petitioners that what is the file?
because
This is one case. The other case is, see the audacity of the officer concerned.
the other case, my lord,
And he is asking the other authority, the NHAI, to approve it. Is the NHAI bound to approve?
Submit the concurrence for taking steps.
so that is true, my lord, perhaps.
What
my
is
lord,
this is true?
so,
Is
perhaps-
this the state of affairs of the competent authority?
Perhaps, my lord, they are seeking concurrence.
Even
because
an
of-
arbitrator's award, and which is a statutory mandate, you have made it useless. We see now some cases out here, where in that case which came up today in the morning of where the competent authority, the NHAI or NHDCL writes to the competent authority that look here, don't do all these things.
Yes, yes, I was there, my lord. My lord, perhaps, my lord, with all respect, my lord, perhaps.
No. First of all, why all of you are now in the majority in the parliament? Why don't you change the National Highways Act and have it that forget about anything else? That we don't require any adjudication. We will give whatever it is, and the arbitrator has to listen and then make another provision that the court also has to listen to you before passing an award. Ranges of things can happen out there.
So this is.
Does it take 9 years for you to comply with this? Tell me, how do you fix the Jirat? How do you fix the Jirat? You have to take the Jirat on the basis of whenever you do it,
Yeah.
you have to fix it by taking into account the concurrence of the or ask the forest department as what is the value of the trees. This is how it is done. But does it take for 9 years for getting this thing done?
That is true.
So we will ask the Commissioner and Secretary Revenue Department to be present out here because he has to explain to this that how this is happening. NHAI or NHDCIL will do whatever because they are going to pay. They may say that you pay 5 rupees. Are you going to do that? A trust has been reposed upon the competent authority,
Yes,
and this is the trust.
yes, yes.
This court, this court, by an order dated 28/8/2023, had directed the competent authority to, that is the additional deputy commissioner, Kamrup Rural, to file an affidavit as regards the computation pursuant to the award dated 29/8/2014. দুইটাতে এটা অর্ডারের উপরে by separate orders directed so and so. In WPC number 345/2018, a lame excuse has been made. That too after a period of 9 years for not being able to comply with the directions passed by the arbitrator. In the form of an affidavit. However, in the case in WPC number 1130/2018, the competent authority, that is the additional deputy commissioner, Kamrup Rural, does not even care to file an affidavit, although there is a specific direction passed by this court to do so. And during the course of the hearing, the learned junior government advocate places a set of instructions to the effect that the competent authority has been asking the beneficiary of the acquisition proceedings as to whether to comply with the arbitration award or not. The above actions of the competent authority not only demeans the role of the competent authority, but amounts to a transgression upon the provisions of the National Highways Act 1956. It is the opinion of this court that either the competent authority have not understood the provisions of the Act, provisions of the National Highways Act 1956, or the trust reposed upon it by issuance of a notification under Section 3A of the National Highways Act, small a, of the National Highways Act 1956. Taking into account the above, this court fixes both the matters again on 22nd of September 2023, on which date the additional deputy commissioner, Kamrup Rural, shall be personally present with on which date present at 10:15 a.m. This court further directs gives an additional opportunity to the additional deputy commissioner Kamrup Rural to place before this court the computation arrived at on the basis of the award on the next date, failing which this court would be constrained to pass further consequential directions upon the said official. Let a copy of this order be served upon Mr. R. Bapujari to be sent to the Commissioner and Secretary, Revenue Department for appraisal.
Lordship may also direct my lord the revenue, my lord, additional deputy commissioner to get the records also.
Why should I? So that he comes out here and says that the records are not available. I'm not bothered with all those things.
25.
Correct.
Okay.
Lord, I've written to them twice. They have failed to respond. Once on 25/8 and then on 9/8.
So he has not filed it.
No, my lord. I've also included the orders passed by this honorable court. They have not responded, my lord.
Who? Deputy Commissioner?
DC, yes, my lord. DC, Circle Officer, nobody has responded. my lord. ADC.
Ms. S. Sharma appearing on behalf of the government, the junior government advocate appearing on behalf of the Deputy Commissioner, District Commissioner, Hojai, and Collector Hojai, submits that in spite of the order dated 25/8/2023 being intimated to the
Respondents.
to the home, to the ADC in charge, Hojai.
My lord.
There has been no communication by the said official. From a perusal of the for this court, have duly perused the order dated 25/8/2023, wherein there is a specific direction upon the ADC in charge, Hojai, to file an affidavit by 7th of September 2023 as to how much amount has been disbursed to the petitioner pursuant to the receipt of the said amount by the Office of the Deputy Commissioner, Land Acquisition Branch, Hojai, as far back as in 2017. It was also directed that the affidavit should disclose if no amounts have been disbursed, why so? In spite of the said order having been communicated as submitted by Ms. S. Sharma, the ADC, Hojai, in charge, Hojai, have not cared to do the needful. The above act on the part of the ADC, Hojai, in charge, Hojai, clearly shows that the orders passed by this court have been undermined, which in effect undermines the rule of law. Consequently, this court therefore directs should we issue a bailable warrant?
My lord, let him be present here.
Now we'll ask the SP to arrest him and bring him here. Now, I think these are things which to be, you have informed him, he has not done it.
I would still pray, my lord, let him be personally present. That would be,
No, personal presence is not required because on the earlier occasion I said if you don't file, then the appropriate orders will pass.
I would pray, my lord, that he should be personally present.
We'll ask the SP out here, the commissioner to post it through them
To communicate.
and
this,
arrest him and bring him here.
my lord.
Then only these people will learn.
I pray, my lord.
This is what is happening with your ADCs.
That may not be done at
They
the
show themselves to be subservient to the officials. Is this the rule of law?
It is.
Acts have been totally not given importance.
No, my lord, I would still pray.
Consequently, this court directs the ADC Hojai, in charge Hojai, to be personally present before this court on 18th of September at 10:15 a.m. It is made clear that if the ADC Hojai is not present, this court would further may be constrained to pass appropriate orders of his detention on the next stage.
Right.
Right.
Item 27 and 28.
My lord, by the last order, that is 24/7/23, my lord. There
What
were-
are these matters?
My lord, the matter, what has happened, it's located in that Hill Hafur region area.
Hmm.
My lord, the petitioners, this particular land was settled with them. Even before coming into force of that Guwahati Act,
What about it?
water body act. So now, my lord, when we applied for, my lord, the building permission, then we were given to understand that the permission cannot be given because your land falls in the schedule of the
What
act. Now, my lord, the only option is either they acquire the land or, my lord, they'll have to do something. So that is why on 24/7/23, Prior to that also various other options were exercised, my lord. On 24/7/23, an order was passed to take instruction because there was at one point of time, there was a proposal, my lord, to carve out these two plot land belonging to Assam Sahitya Sabha and the present petitioner out of the purview. So it is in that context, lordship, that I asked them to obtain the instruction.
As per my instruction, my lord, authority is going to acquire the land, and for that, one date is fixed on 18/9/2003.
In both the cases,
No, first one, my lord.
which one?
Item
My lord,
27, my lord.
7457.
Yes, my lord.
Yes.
You are going to acquire this land.
Yes, my lord.
And the other one? Other one is what?
Well, other one, they have filed an IA. My lord, there was one point of time where we entered into
No,
an
no, there is another petition, Versa Technotrade Private Limited. What is this?
He had entered into the other develop the entire project with us.
So what remains if they acquire?
well, nothing actually, that matter can't be connected with this.
No, it can't be unnecessary. He wants
Yes,
an
but
order
remaining
so that
of the
tomorrow
civil
he
code, my
files
lord,
a
it
suit for
feels-
damages.
Ah. Yes, yes. Okay, okay. এই agreement করে যে violate করতে তুমি ঠিক করো।
So there is a date fixed on 18/9/2023 for joint verification. So I think we'll have it after 3 months, let's see, or 2 months.
Let the process go on as they are contemplating. Yes.
That is the only way how they are contemplating of taking over as land
Can
acquisition.
you record that in the order?
I may be allowed to bring on this instruction on record by affidavit, my.
No, following that.
I will put it as X.
Right.
Or if you lose it materially, then you can put it. Pursuant to the order dated 24/7/2023, Ms. M. Borman, the junior government advocate, have placed before this court an instructions dated 1/9/2023 issued by the additional district commissioner, Kamrup Kamrup Metro, wherein it has been mentioned that there is a move for acquisition of 30 bighas of land covered by DAG number 602/1074 old 3785 new under Hengraberi village, which have been settled with the petitioner. And for that purpose, there are certain verifications to be carried out in that regard. The said instruction is kept on record along with the enclosures are kept on record and marked with the letter X. To list the matter up on 8th of November for further update as regards the acquisition proceedings, acquisition of the petitioner's land.
Public.
29.
If or not, no.
May it please your lordship. Lordship, the petitioner in this incident case, he had lodged an FIR before the Commissioner of Police, Kamrup Metro, that is the respondent number 3, disclosing prima facie the commission of serious cognizable offences against certain top police officials in the state. Lordship, after the receipt of the FIR, the same was forwarded to the officer in charge, Bhangagar PS, that is respondent number 4, and accordingly he made an entry in the general diary. Thereafter, Lordship, as per the apprehensions of the petitioner, he was apprehensive because the allegations were against the top police official. he preferred a petition under section 156 clause 3 of the CRPC before the learned trial court to bring forth the status report as regards the
Under 156(3).
3, Lord. To bring forth the status report as well as to ascertain whether the investigation is being conducted properly or not. Thereafter, Lordship, after the receipt of status report and to the utter surprise of the petitioner, it came to the petitioner's light that the FIR was not even registered at first place. And to make matters worse, an inquiry officer was deputed by the concerned OC. And that inquiry officer, after doing a perfunctory job of making a preliminary inquiry, he furnished a report that no offense, prima facie offense is being made out, as alleged by the petitioner. Now, Lordship, that particular status report, perhaps it was considered as a report B under section 173 of a closure report under the CRPC, that was tagged as a part of the record. So against that, we preferred a protest petition under section 173 clause 8 of CRPC. That petition was also rejected by the learned trial court. So Lordship, hence we have approached before this.
Then why are you not challenging under 482 or 400, this 397?
Lordship, understandably.
What is this? How can this court do all these things when their court have already taken note of?
Lordship.
Have you filed that?
No, Lordship. This was filed
I
in
think you need to file that. Because the protest petition, I think you will have to file a revision against that 397-401.
So, Lordship, this is a 2018 matter.
Huh?
This is a matter of 2018.
You have that order date by which it was rejected?
Lordship, I believe
Your
annexed-
protest petition was rejected?
Yes, Lordship. It is annexed G in page number 49. Page number 49, Lordship. I have annexed that particular order.
Have you challenged that order?
Lordship, we are challenging this order by this writ petition itself.
Huh? Where?
Lordship, page 49 is the rejection order.
The FI was never lodged.
FIR was lodged, Lordship.
Where?
Lordship, the FIR is page number 38. It was lodged before the Commissioner of Police.
No, why is the court then saying that this court cannot direct for lodging an FIR? Where is the FIR?
Lordship, page 38.
No, that is an FIR. Where is it? You are saying that it has been registered.
No, it was not registered, Lordship.
That is what I am saying. You see, this order which has been passed. Where is that? Where's that order?
Lordship, page 49.
Huh?
49.
Yes, this order, what is this order type of order? Learned additional public submits that the instant petition prepared by the petitioner under 173A is not maintainable as under the aforesaid section. This court is not empowered to direct the police station to register a case on the FIR lodged by the petitioner. I have carefully considered the above submissions rendered by the learned counsel for the parties in the light of the relevant provisions of section 178 relates to further investigation of the case. This section does not allow the prayer of the question. Therefore, the petition prepared by the ER is devoid. Right? What type of order is this?
So Lordship, we have essentially challenged these three aspects. Firstly, non-registration of FIR, although it prima facie disclosed cognizable offense.
No, that is there, but the only thing is, can this court direct conversion of this matter to, because this is 226, it will be very difficult. Can this court convert it to 482 or 401?
Lordship, otherwise, based on the judgments that have gone through.
No, you have a case. Proper case. But you only ask for registration of an FIR.
Registration of the FIR. That may as well report in final report. But at
And what
least,
does that Supreme Court judgment say? The 5 judges bench?
sir, the Lordship, the Lalita Kumari judgment.
Lalita Kumari. It
Lordship,
is only to be seen as to whether a cognizable case has been made or not. Yes, who is appearing for the respondents here?
Lordship.
Yes, what is your stand?
Look, in the affidavit, we have stated that there is nothing has been found against the allegation made by the petitioner. And regarding my lord, that FIR was lost before the commissioner police.
So what is the
Already
problem?
GST was, GST
Commissioner
was-
of Police, in view of section 36 of the CRPC, why not the Commissioner of Police can very well be receive the
that
FIR?
can be-
Well,
Only my lord, that GDNT was done only that regarding the receiving of the step.
no, why the FIR was not registered?
That instruction, my lord, that information, I don't have now. Why it was not being registered? But in the affidavit also, it is silent regarding that.
We call for the case records, huh?
Lordship.
Upon hearing the learned counsel for the parties, and what is the number of this case of 156.3, your application? Hmm?
Lordship, it was just.
No, what, no, in what case? There has to be a number.
Lordship, it was Bhangaghar PS GDE number 641 dated 20.
That is GD entry number 4. But what is the court? Has the court passed an order on without anything? And what is the special judge doing with this type of application?
Lordship, perhaps the allegations were of corruption in this case.
So,
Hence,
if it is of corruption, then it goes to the special judge.
Lordship, sections 13 as well as 7.
You are doing it under the Prevention of Corruption Act.
Yes, your lord.
But what do you say about one judgment? When it says that without sanction, you can't go under 156.
Lordship, I believe, to my limited knowledge, that was with respect to Maharashtra. Lordship,
There's a, that's a 3 judges bench. Thereafter 2 judges, no, that's also 2 judges bench of Justice Sikri. And then there is another judgment of Justice Salimashwar, where he has referred it to a larger bench. Can he give under, because there in the earlier judgment it has been mentioned that 156(3), no directions can be issued without a sanction.
Lordship, but
How do you
otherwise,
take care of that?
Lordship, but otherwise the FIR ought to have been registered at first.
That is the problem. That is the judgment, that is the problem with the judgment. Although it has been referred to a larger bench, it's a different thing, but the matter has not been heard by the Supreme Court. But I passed an order in 2011-12, I passed a judgment. Have a look out there. You can, because I said in that case, following that Justice Salimashwar's judgment, and more particularly paragraph 41 of the next judgment of Justice Salimashwar, that there's a leeway being given how it can be done. I think you need to go through it, because how can this court otherwise direct 156(3) in view of that those two judgments?
Fair enough.
The manner in which I got out from that case was how I said that no, nothing. There was a, what has happened in that case. Complaint under 156(3) was filed before the special judge. The special judge directed inquiry under 156(3). Upon making the inquiry, it was found out that those persons, the chief engineer was no longer involved, against whom the direction was sought for. And it was found that there were 2 other persons who were involved. And on the basis of that, the charge sheet was given. And not the charge sheet, the report was given seeking sanction. Now the question is, those 2 persons comes up and says, takes the benefit of Justice Sikri's judgment and says that the court could not have governed under 156(3). But I say that it would have been a good case if we have applied 156(3) or that judgment, if it was a case of the chief engineer.
Right.
But not the other 2 who were found during the course of investigation. Because in paragraph 41 of the judgment of Justice Salimashwar, he says that if in the meantime he was removed, that person's name was removed from the complaint, and it was said that if in the meantime a person concerned, any further investigation, it is found that this person is involved, he can be then roped in.
Alright.
So this is how I passed the judgment also. Have a look at it. We'll have it after summer vacations. Yeah. Let the matter be listed after the puja vacations. In the meantime, the petitioner shall take necessary instruction. You find out these 2 things. Can I convert it? And the second is how to tackle with 156.
All.
30.
Deeply obliged.
Yes, Mr. Roy.
Please, your lord.
In this case, principal amount has been paid, my lord.
Eh?
Principal amount has been paid. Only the interest part left.
Interest is how much?
Interest will be around
Total payable amount lordship is 13,56,712.
Eh?
Total amount is lordship 13,56,712, and they have paid lordship 8,49,912.
They paid the principal,
principal amount.
And
not the interest.
not the interest.
How do they say that they have paid the principal? No, how can he choose that I have paid the principal, not the interest? Because the moment he says that he has paid the principal, there cannot be an interest on interest. Very clever to say for him to make that submission.
My lord.
Yes.
Uh,
Who are you?
I'm STC, my lord.
And you?
Lordship, I'm the claimant, Lordship. In the claim petition, Lordship, the award
Claimant under what?
MSCP.
Oh, no. Then in that case, it will be. Has it been mentioned that you the interest will be paid? The
Yes,
amount? No, the amount will be first a portion towards the interest principal. No. So it must have been said so and so amount plus interest.
Plus interest.
Then how can he say to be? I paid only the principal.
Lordship, can you come to page number 29?
That's
29.
6% interest has been awarded.
Yes. What are you going to do?
My lord, we are waiting for the budget matter actually.
When?
Maybe within
Don't
a
say
month.
this
Within
in
a month.
March. Huh?
Within a month, my lord.
Okay, we'll have it after Puja vacation.
Fine.
Give a final date when you are
Then,
paying.
Lordship,
Because you can't say it to be the principal being
Right.
paid.
yes, sir. In the
See
meanwhile,
paragraph 52 of Gurpreet Singh. Constitution bench judgment. Have a look. Mr. L.J. Roy, the learned senior counsel appearing on behalf of the STC, seeks for an accommodation for a month on account of certain budget proposals being placed. To list the matter again on 8th of November 2023. On the same date, the Mr. Roy shall, the learned counsel appearing on behalf of the STC shall apprise this court as to what is the present status of the payments so to be made to the paid to the petition.
Hello.
31,
Hey, please, Your Lordship, 31 may be taken Thursday or Tuesday, my lord.
What?
My lord, I could not prepare because of my, I got injury. That's why, my lord.
We'll have it some other day.
Yes, my
We were
lord.
informed yesterday by the London.
Okay, we'll have it some other day.
Yes,
When?
my lord.
No, not so soon. Get your eyes revealed. What is this case matter
This is-
pertains to?
There is a stay
Challenging a provisional attachment order.
under PMLA Act.
Is a stay?
Yes, my
Lordship.
lord.
So you're
Stay of not
enjoying
the
a stay?
proceeding, only the provisional
PMLA,
attachment.
provisional,
Huh?
that
There is stay of not of the proceeding. The proceeding is continuing. The cognizance has also been taken by the learned special judge, but the provisional attachment order is stayed. Lord. Only the order
So you are protected
for the time being. Lord.
for the prime minister. When should we hear?
But can it be after 3 weeks? We'll file a affidavit in reply also. They have filed their affidavit.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation for filing a reply to the affidavit in opposition filed by the respondent number 1 and 2. Let's list the matter again on
last
17th of November 2023.
some, my lord, before 7 in September, October, my lord, middle of October.
Middle of October, courts are closed. Why? Why do you want it to?
Because stay is there, my lord. Provisional attachment order has been stayed, my lord.
Oh.
First week of October, my,
Okay, to be listed on 11th of October.
yes, my lord. Yes,
David, can it be? David,
11. I'm giving you 1 month. You are asking for 3 weeks.
yes, sir. My-
but the interim may kindly be.
It is already there in interim orders to continue until further orders. If I pass anything, I will limit it. You heard? Are we? Who will? Who will? Yes, Mr. Sheikh, what is this matter?
production list item number 7.
You mentioned it in the morning.
Huh?
As you mentioned in the morning.
Yes.
Some evidence. Your lordship permitted that it will be taken up.
Yes, what is this?
But the case in short is this matter. We are for 5th generation occupying Patta land. So land was eroded away, but ultimately there are 3,000 vigha of land. In this 3,000 vigha of land, my lord, on a fine morning,
were evicted, our residential houses were destroyed. Thereafter, what happened, my lord? We are living in by constructing some shed. That is another aspect of the matter. No compensation has been given as per the provision of.
Are you in possession?
No, my lord, I am not in possession now because, my lord, we have been evicted
Then
from the land.
how can you be allowed to harvest?
No, no, thing is this, my lord. When we are, recently we have been evicted, my lord, on 20.
No, understood, but how can you harvest?
Yes, my lord, we are by the periphery of the land. We
So,
raised the cultivation, my lord. We were evicted on 27/6/2023.
Mr. Sheikh, this is not an urgent matter to be taken up today.
No, my
We'll
lord.
have it on Wednesday. This will matter again on
No, my lord,
Wednesday.
my route will be dried up, my lord.
It won't happen anything. Jute won't die and dried jute is better.
It is to be.
No,
understood,
no,
my lord.
Mr. Sheikh, nothing doing.
It-
This is not a matter of urgency. He shouldn't have
My
mentioned
lord,
this matter.
my lord,
I trust and give these permissions out there thinking
My
that the
lord,
matter is urgent.
my
This
lord,
matter,
your
no, Mr.
lordship,
Sheikh,
Your lordship, one thing, my lord, your lordship will take the decision. Let me place, my.
no,
No, my lord.
no, Mr.
About
no,
1 crore
Mr.
50 lakhs of rupees, my lord, value of the truth. That will be totally
It
destroyed.
can wait till Wednesday.
Obliged.
Item number 34.
May I please, Lord?
Hmm.
Matter relates to the acquisition of land, Lord. On the last
Mhm.
occasion, Lordship, the respondent also they filed their agreement, Lordship. So, Lordship, this number.
You have filed an affidavit when?
On the last.
On
date,
30, Lordship.
20.
You said that the affidavit has been filed. Respondent number 2 submits the affidavit in opposition as director has been filed on 2/8. Has been filed. The matter, the affidavit has not been brought on record.
It was filed on my lord 22/8, Lordship.
23.
Okay.
23.
Respondent number 3 has filed. What is your case, Mr. Counsel?
Matters related to the acquisition of land of the petitioner's, Lordship. Without due procedure of law, Lordship. Kindly come to the page 19, Lordship.
Restraining them from carrying out construction of MNP road at village so and so under so and so since the parts of the land are patta land of the petitioner. Inasmuch as the same has not been acquired. Yes, what do they say?
Page 19, Lordship. Respondent number 2 has
As to
issued the
the
demarcation notice.
petitioners were the owners and possessors of the two units, but during the year 89 in Konpeka order near the land was in question was made fast for construction of human and natural capital. Mr. Hendik, how this land has been acquired?
Lordship not acquired, my lord.
Then how did it become khas?
Lordship, in our affidavit, Lordship, may kindly see the
Paragraph 6.
Lordship.
How this land has become khas?
That they,
You have filed a reply.
Lordship, I informed to the petitioner, Lordship, they are come, within next day, they will come. Next week, Lordship.
Council for the petitioner submits that he requires 3 weeks time for filing a reply. This is the matter after 3 weeks.
I am for the villagers. It may be fixed. We are suffering. They have not allowed to run this through this road. Lordship. They have already blocked this road. Lordship. We are the villagers. Lordship. They have implemented us as a respondent in this proceeding. Lordship.
You paid a compensation to them.
They are
35.
not allowing. We have no alternative road also. Lordship.
Can't help it. You are not the petitioner here.
Not taking it.
File only.
35.
File an IA then. Yes, Mr. Upadhyay.
Lord,
Tender of any value? No. Nothing remains.
nothing remains, Lord.
Mr. N. Upadhyay, Learning Council
Upadhyay.
appearing on behalf of the Irrigation Department submits that the tender in question Which tender number?
Lordship,
ACI, T27, ETI,
Huh?
21.
page 12.
Is the number of the tender?
That is it. Page 12. ACI T-27, ET-I,
The number
2021.
450.
So status information regarding e-tender
No,
NIT number.
No, what is this? And later on, as directed by the High Court in Twente and observing the length of work have been awarded. Solar powered MTA Twente Pakimura, Twente amounting to rupees 128 lakh. So what did you do? You bifurcated it
Lordship, yes, we have bifurcated.
and gave all to a different person,
Lordship.
including him.
He was not there.
I was
probably.
not there.
Yes, not there.
Huh? You are not there. So that work has been completed.
Completed.
So was there any stay?
No, Lordship.
No.
Petitioner's prayer, Lordship, to cancel the e-tender, Lord.
The Learned Council, Mr. N.N. Upadhyay, appearing on behalf of the Irrigation Department, subject to the order, pursuant to the order dated 28/8/2023, passed by this court, has apprised this court that the said tender proceeding was withdrawn. That the notice inviting tender dated 10/7/2021, which was impugned in the instant writ petition, was withdrawn by the department, and subsequently the said work have been bifurcated into as many as 10 works, which have been since been completed. This is completed.
Lordship, I'm not saying, this is already allotted, Lordship, therefore
Have been allotted. Which aspect of the matter could be seen from the instructions placed on record by the Learned Council. The said instruction is kept on record and marked with the letter X. In that view of the matter, nothing survives in the instant writ petition for which the same stands closed.
Obliged, Lord.
36,
Yes, agriculture. What is your instruction?
Out of the matter become infructuous.
Ms. G. Swami,
Yes.
appearing on behalf of the petitioner, submits that the writ petition has already become infructuous, for which infructuous, in view of the fact, has already become infructuous. Taking into account the said submission, the instant writ petition stands closed on as it has become infructuous. The interim order dated 22/10/2021 accordingly it stands vacated.
37,
Yes, who is there? 30.
37,
And for the respondent, Lord.
No stay, nothing. Have you shifted? Have you shifted?
No, Lord.
Is it in the same location?
My Lord, that instruction I don't have. My Lord, that copy I think notes served to us, lordship, extra copy, we could not be communicated.
None appears on behalf of the petitioner on call. Who are you?
Lordship, I filed the impleachment petition, Lord,
For what?
for impleachment, Lord,
Why?
because Lordship, earlier we had challenged the.
Who are
sitting
you?
order. I am the earlier managing committee, or president of earlier managing committee. At present, I am the guardian of the, one of the guardian, Lord,
Guardian of what?
children, Lord, who is prosecuting study.
In that project,
Yes, in this. Anganwadi
ICDS
center.
project.
Yes, Lord.
Now, has it been shifted?
No, Lordship. So far, our at present information, the Anganwadi center have been functioning from two places, Lordship.
No. There is no interim order, nothing to that effect.
Yes, Lord.
Here, there is an order being passed on 9/1 Imam,
Lordship,
wherein it has been mentioned.
Lordship, first shifting order I had challenged, Lordship, before this honorable court, and the
No,
order.
here challenge in the interest of public service, proper implementation of the Anganwadi service and to restore the original sanction and setup of Islampur so and so. The office for shifting of this Anganwadi center issued on AI is hereby cancelled. Shall be functioning with its original surveyed population with immediate effect. Tell. So this order has been put to challenge.
Yes, Lord.
How are you agreed?
Lordship, kindly see that order. Everything will be clear, Lordship, in this order. I was the writ petitioner in this case, Lord.
So nothing. You were only given a compensatory order.
Yes, Lordship. Pursuant to this order, Lordship, this implement order has been passed, Lordship, which is challenged in this writ petition, Lordship, and directed the worker authority to function its original place of functioning, Lord.
So is it functioning?
At present, functioning, Lordship, from two places functioning.
So that is their lookout.
Yes,
You have to file a writ petition for that. None appears on behalf of the petitioner on call, taking into account Mr. J. Hendrick appearing on behalf of the
State government.
state government. On behalf of the respondents, respondent authority submits that he has no instructions in the matter.
1 to 4.
Taking into account the above, taking into account that the petitioner is not represented, list the matter on 25th of September 2023. It is made clear that if the petitioner is not represented on the next date, the instant petition shall be dismissed.
Lordship, my mistake is for improvement.
Why do you want the miscase? We will consider your miscase when the other side is there. Otherwise, we'll dismiss the matter. Your miscase becomes improper.
39.
Yes. Oh, it's timely. Nikki.
Thirty-nine.
Given?
39, Lordship, I need some time to monitor.
Mr. J. Hendrick appearing on behalf of the respondent, Revenue Department 6 for an accommodation of 3 weeks, list the matter up to the Puja vacations. The interim order, list the matter of on 20/11/2023, interim order passed earlier shall continue till then.
40.
May I please your lordship?
Yes, Mr. Chaudhary.
Lordship, the conducting council, my senior, he's on legs.
Who?
Lordship, he Kolita.
Very well.
Lordship, he is on legs, so the matter may be taken on Tuesday or Thursday.
Why? Tuesdays and Thursdays are specifically days fixed by this court only for the purpose of taking up matters for final disposal. Why should we fix it
Lordship, any other day in the next week.
next week? There's a long order being passed by this court
Yes.
on 22/3, 23/6. What is this termination?
My lord, the termination order was passed long back.
Hmm.
Now the Oil India themselves had extended the contract from time to time. The setting up of some compressor, my lord, for taming the natural gas which is done. My lord, they wanted.
You have not filed affidavit, or
Yeah.
affidavit, not filed.
Affidavit file also, sir.
No
They have
affidavit.
not filed affidavit.
No. Why you not filed affidavit? And you are asking that a matter to be taken immediately? Why?
They have not filed it.
Lordship, I don't have instructions.
You
regarding
think that the
this.
court's list is just for the sake of it?
No, Lordship.
Huh?
But the
Is it your assumption that the court's list is only for the sake of it?
no,
And we used to be lawyers, it was a hard thing to get the matter listed before the court. Anyway, we are not interested. It reveals that there is a,
Well, there is one aspect, there were no interim order. All that was the order that has been passed, though it's a very long order, my lord.
Oh.
In effect, my lord, our representations were pending before the authority, and authority were asked to review, review the order of termination by disposing of our representation. And till then, my lord, they were asked not to proceed with the tender. Now, my lord, they have disposed of our representation, which we have brought on record by filing affidavit in opposition, where we can demonstrate, my lord, where the reasons cited are wrong, palpably wrong. Well, they want to go for a fresh tender. Only for the fresh tender, it only the mobilization period is 300. On the contrary, we are saying out of the 8 wells, my lord, 5 we can install within 3 we install within 72 hours, and 2 we can install within maybe, my lord, 10-15 days. Only in respect of 1, because there is a question of acquiring garden land is concerned, my lord. There we can't do anything unless, my lord, Government of Assam in the Revenue Settlement Department does that. There we are praying for 3 months time. Otherwise, my lord,
but Mr. Chaudhary, the question is, I don't know, although the ordinate bench have passed a long order out there, but how can you stay at termination?
no, there is no stay.
No, you can't stay. So
There is
the
no
matter
stay.
needs to be finally
My lord,
trust off.
suppose only thing is, my lord, they will not proceed with the fresh tender. That is the only.
There is no order to that effect also.
No, but now there is a fresh tender, my lord, that we have challenged.
Huh?
Earlier, if your lordship will
Where
kindly
there
have
is
a look-
another petition.
last order, my lord.
Of?
Order dated, my lord. Order dated 23/6/23.
You have which one? The order dated 3rd of
The only
August.
order in this case, my lord.
3rd
That
of
is-
August 2023.
23/6/23 order is there, my lord. There is one. more order.
Understood, but there is another order passed now
Yes,
on 3rd of August 2023. Have you challenged this order?
no. Yes,
Where?
by way of filing additional affidavit, brought on record.
But Chaudhary, how can you do that? Don't you think that you have to file a writ?
Continuation of the original proceeding, my lord.
Maybe, but there is a direction passed by the court
Yes.
to pass a reasoned order. And if you don't challenge it,
No, yes. So technically, that can be done, my lord. We can brought on by, meanwhile, by Monday itself, we'll find it.
I think that is
My only prayer is, my lord, because earlier the order was like this. I'm just reading that sentence, my lord. Before finalizing the bidding process initiated by NIT dated 15/12/22, it is expected the respondent authority, oil authorities, by giving a final consideration to the said to representation, shall pass a reason order on or before return it to them. Idea was, my lord, before you go ahead with the finalization of the tender, please you dispose of the record, which they have done.
but
and
that
we
is
have
the
brought on record.
problem.
Technically,
Unless you don't challenge this,
putting on record, my lord. Only some protection, my lord, that they will not finalize the tender.
very difficult. You are not challenged it.
My lord, in a 226 proceeding, perhaps, my lord, lordship can take note of it. I can appreciate in a civil suit, of course, it is a must amendment.
I would have understood if without anything, this order is passed. This court would definitely. But when this court had directed to pass a reasoned order, and on the basis of this court's order, the order has been passed, don't you think that without challenging it, it would be very difficult?
No, yes, correct. We have, whether, my lord, we can challenge it by way of an additional affidavit.
Anyways, till date, they have not issued a NIT.
Yes.
So obviously,
They have issued an NIT, but they have not finalized it.
I think you can file it by Monday.
Monday.
We'll have it on then Wednesday,
Wednesday, yes.
this one.
Done. First one, call it on Wednesday.
You file it on Monday, then we'll have it on Wednesday. List the matter again on Wednesday. On which day? Mr. Kane Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, had submitted that in pursuance to the order dated 23/6/2023, the executive director of the respondent company had passed an order on 3/8/2023, whereby the representation submitted by the petitioner dated 25/4/2023 and 12/5/2023 has been rejected. First up, the learned senior counsel submits that the petitioner is in the process of challenging the said order. It is also relevant to take note of that by an order dated 23/6/2023, this court did not pass any interim protection, interim orders. In the meantime, pass an interim order as sought for.
Or a limited interim order was passed, my lord, saying
As sought for. Under such circumstances, Mr. Kane Chaudhary, the learned senior counsel, expresses urgency in the matter. Taking into account the above, list the matter again on
16th, my lord.
Huh?
16 will be Wednesday.
16th is Saturday.
14th, sorry.
13th?
14th, my lord.
13th is Wednesday. On 13th of September 2023.
Leave them.
41.
In this case, the respondent authority has already submitted their affidavit to this. They have passed an order also. This is regarding the petition writer's case. But then we would like to submit our opposition reply.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation of 4 weeks to file an affidavit in reply to the affidavit in opposition. This is the matter up to the Pujari.
Sir, we will not require 4 weeks because this is an urgent matter. So we will make 1 week. Within the week we will file it. Actually, the
When did they file the affidavit?
Pardon me?
When did they file the affidavit?
25th of August, my lord.
Then why haven't you filed it till now?
I understand, my lord, because the petitioner who has been signing, but he was on Chennai. He went to Chennai. He was sick today. He will be arriving today only. Our affidavit is ready, but
This-
then signature is required.
For 3 weeks, list the matter on 11th of October. এই নতুন এখন কোড বলবো ডিক্টেরি হয়ে থাকে এই উইক খোলা আছে তো 16 তারিখ ওটা পিছতে 19 তারিখ
42.
এখন কোড বলে এখন আসছিল না Yes, Mr. Mishra.
My lord, by way of this petition, my lord, I am challenging 2 orders, my lord. One is the original order and second is the appellate order.
Huh?
I am challenging 2 orders, my lord. First is the original order, my lord, whereby service tax demand was raised, my lord. I put the order in challenge in appeal, my lord. Appeal was dismissed on the point of time barred, my lord. We have argued before the authority that our case is not time barred in view of the Supreme Court's order of extension of limitation, my lord. That was not considered, my lord.
Oh, that time.
That time, my lord. Now, what the order was passed on 28/1/22, my lord. and it was communicated on.
So the
6th of-
period was there till that time. 19,
From 28,
period was there till when?
90 days from 1st of March, my lord.
Hmm?
90 days from 1st of March, to my understanding.
Until the balance period of limitation remaining as on demand, if any, shall be. Okay. So the appeal has been rejected on the ground of limitation.
Limitation.
107, 1 month.
But it is under finance act, my lord. Provisions are almost same, my lord. Here 2 months plus 1 month.
Huh?
It is in the finance act 1994. Here 2 months plus 1 month. 3 months total.
Okay. So they did not extend it because of the statutory mandate,
My lord.
without taking into account the order passed by the yeah.
They have taken into account, they have observed that my limitation is not expired in between that period. Lord, you will see the observation at page 81. We start from page 80, my lord. Page, paragraph 7 onward, my.
Noted that the when did the period of limitation expire?
My lord, the order was passed on 28/1, my lord.
Huh?
The order was, impugn order was passed on 28/1/22. And it was communicated to me on 6/2/22. I prepared an appeal on 17/5/22, my lord.
What was the period?
As per the sumo total extension, my page 70 have annexed.
2 months and 1 month.
Yes, my lord, 2 months and 1 month.
So this 90 days.
90 days, my lord.
So 90 days from?
My lord.
From the date of your receipt.
Yes, my lord.
Received when?
6th of February, my lord.
6th of February. 90 days will be?
On my lord.
6th of February,
6/4/22.
2022. Your period of limitation does not expire here. So you say that in Iman, for notwithstanding the actual balance of the period, all persons shall have a limitation period of 90 days from one where the limitation has expired. In the So you filed it on 17,
My lord.
5,
My lord.
delayed by how much?
Lord, it is delayed by
4-5 days.
11 days, my lord.
So what is your submission?
Otherwise, my lord, I should be given a benefit of this extension, my lord. Otherwise, I have a case on merit, my lord. On merit, I have not required to pay any tax, my lord.
No. Why should I give the benefit? What is your submission?
Because, my lord, the balance is irrespective of the balance period, my lord. I should be given 90 days as per this Supreme Court's order, my lord. So I am claiming in,
So 90 days from 1/3/2022.
my lord. If it's from 1/3/2022, my lord, my limitation will expire on 29th of May, my lord. Then my appeal will be well within time, my lord.
In the event that the actual balance period limitation remaining with effect for me is greater than 90 days, the longer period. So you mean to say, even if within that period the limitation did not expire,
My lord.
thereafter also from 1/3/2022 to 9/16, 1/6/2022, 90 days, na?
My-
13/14/15.
Yes, ma'am. It will be 29th, my 20 days.
Till
April,
35.
29th of May, 90 days will be
90 days.
Till 25.
We are 90 days, na? 29th of May. So till 29th of May, the limitation was there.
My lord.
Yes, madam. What do you say?
Lordship, there are comments actually received, your lordship. May I place one paragraph or otherwise I may file may be allowed to file affidavit, your lordship.
What is there to file affidavit? It is a question of law.
Yes, your lordship. As per the instruction, may I read, your lordship? In the instant case, the normal period of limitation expired on 6/4/2022, which was beyond 15/3/2020 to 28/2/2022 as covered by the order of Honorable Supreme Court. Accordingly, the benefit provided by the appointed order of Honorable Supreme Court is not applicable.
No,
in
you
this
see,
case.
anybody's limitation had expired prior to 28/2/2022. I'm just giving you an example.
Yes, yes.
He gets the benefit from 1/3/2022 to 29/5/2022. He gets.
Hmm.
But a person whose limitation expires after 1/3
Hmm.
would not get the same benefit. Wouldn't that be a bit very difficult to appreciate? Think about it. We'll have it some other day. Well, because this stay, unnecessary it is being stayed. What is happening? Let it be decided on merits. If we can give an interpretation to that effect, let it be decided on merits by condoning this and giving an interpretation that this will also apply to those. If from 1/3, he will also get the benefit of 90 days from 1/3 to so and so. And if he gets the benefit from 1/3, his time is there till 29/5. And as such, it will be within the limitation period. Then what happens? Unnecessarily for 7 days, here and there, you are fighting out there. And you are losing the revenue. What to do?
After next week, your lordship.
Is that matter after 2 weeks? Dated a review. Is the matter after 2 weeks? Interim order passed earlier shall continue till then. Give a date, huh?
Okay.
43.
Wait, please, your lordship. In this case, your lordship, the premises of the petitioner has been put under seal without any authority of law since 11/5/2023.
Yes, Mr.
Lordship, my lord, we already been communicated, my lord, no instruction have been received, my lord.
Because there was a specific direction on the last occasion, either to file affidavit or
Or
to
instruction.
take instruction. So that
Or
the
we
matter will be disposed.
We have been communicated on, my lord, 10/8, lordship. It was come on
Mr.
7.
J. Hendek appearing on behalf of the revenue,
No, lordship, there is statement. My lord, the respondent.
appearing on behalf of the state government submits that there has been no instructions received from the, from whom?
My lord, it is from, my lord, respond about 2, 3, and 4. lordship.
Who is it?
My lord,
District
the
Commissioner.
District Commissioner, Superintendent Police, and my lord, OC.
From the respond number 2, 3, and 4, in spite of the communication being sent on 10/8/2023. So, taking into account the above, Mr. M.H. Losko, the learned counsel appearing on behalf of the petitioner expresses urgency in the matter. So taking into account this, the matter on 27th of September 2023. So it is made clear that the respondents shall without fail obtain the instructions in this regard, as sought for by the order dated 7/8/2000.
Obliged, lordship.
Look at that. Yes,
Well, I'm agreed with the stop construction notice.
huh?
That I was constructing a building and that has been asked to, I have been asked to stop construction. Now, today morning, my lord, they have municipality board has filed their affidavit. I will require 2 weeks time to file my reply.
The learned counsel appearing on behalf of the petitioner submits that the respondent number 2, 3, and 4 have filed an affidavit today, and he would like to file, the respondent, the petitioner would like to rebut to the said statements made in the affidavit in opposition. This is the matter of the is the matter on 11th of October to not 11th.
Well,
On
can it be on
16th of October 2023. Pusto. Yes, Mr. Shetty, got the order.
Today, Honorable Court was pleased to fix the matter, my lord, for passing
Eh?
for passing the order, appropriate order. My lord, here, Lordship will find, my lord, after taking the, my lord, in 2017, my lord,
Yes,
in 2017, my lord, I purchased the building by way of registered entity. And at that time, my lord, the ground floor as well as first floor was there, man, and the occupancy were there. Then, my lord, in 2022, my lord, when this Tinsukia Municipal Court came, my lord, then they found some irregularities in the first floor and ground floor, my lord. It was the ground floor was constructed in 1985, and the first floor
is
was,
it paying for Tinsukia Municipal Board?
and first floor was constructed in 2009, 1. And that part has been regularized by the Tinsukia Municipal Court, my lord, by taking the appropriate fees, my lord. Now, my lord, in 2008, 23 August, my lord, when I applied for the permission for second floor, my lord, for second floor construction, my lord. After considering all this aspect, my lord, this permission was granted to the petitioner, my lord. Lordship will find at page 27, my lord.
You are challenging an order of 9/8/2023
23, my
to
lord.
suspend construction work until further orders.
No, now,
Yes.
now,
Now,
Lord,
are you challenging that order?
yes. Now, why I am saying, my lord,
How can you get an interim order?
Lordship,
Tell me, if I give an interim order, I'll have to dispose of the matter.
that's true.
Then?
So only anxiety, my lord, since I got the building permission, and on the basis of the building permission, the second floor has been constructed as per the rules and regulations, whatever they have assigned, my lord. And accordingly, my lord, some of the persons, neighborer, my lord, they complained before the authority concerned, that was resolved, and subsequently they filed a suit, my lord, against me, saying that there is lacking of parking area, all these things, my lord. Now this this WSN written objection was also filed by the Tinsukia Municipal Board, which was filed in my favor, my lord. Lordship may have
Now, have you stopped construction or not?
yes, now because of the, my lord, I have to stop the construction because I cannot go against the municipal board. Once, my lord, case is pending.
You have been given the permission to have parking space for cars.
Yeah.
The allegation is that the parking space is such that you can put only scooters, not vehicles.
Now,
After verification.
parking, my lord, here, that second floor is for storeroom, my lord,
No, no, I'm saying about the parking.
parking. And for storeroom, my lord,
You want to break it?
Lordship,
and
You want to break off?
Lordship, civil suit is also pending, Lordship. On 12th, the next, I have
And-
informed that on 12th, the next hearing is there.
Civil suit filed by whom?
By the complainant, Lordship. It's similar,
For
same
that-
issue, Lordship.
same issue.
The civil suit shall not bar you.
Not
taking-
by us, because we are waiting for the, because on 12th, the next hearing was there, Lordship.
Over. So you are not going to take any action?
Lordship, we will
And-
not.
And Lordship, have a look at page 34, my lord.
Why did you issue this notice when the civil suit was pending there?
Lordship, that's why, because Lordship,
He has started the construction, Lordship. Therefore, after investigation, Lordship's site visit, it was been issued now. Because prior to that, there
On
was
one
a
hand, you are not taking any action because of the civil suit. On the other hand, because of the civil suit, you have taken action. Ready?
no, Lordship. On civil suit, there was a order. I have instructed that there was an order to revisit the site. There was a joint inspection, Lordship. That thereafter, this order has been passed.
There is 10 lordship will find at page 39, my lord, in the civil suit, my lord. It
Is
in
there
my-
any violation by them?
Lordship,
Is there any violation by them?
Lordship, up to date.
File your affidavit,
Lordship,
2 weeks.
Lordship,
File an affidavit saying as to whether there is any violation as per your
Lordship,
verification.
Lordship.
We'll then consider.
There is a violation, Lordship. As per this notice, Lordship, there is
That I have seen it.
Lordship, that I've said, Lordship.
Parking is such that vehicles can't go inside.
Can't go.
scooter
Only
will-
scooters can move.
My lord, apart from that, my lord, I must,
Mr. The Tinsukia Municipal Board, Mr. S.S. Roy appears on, represents the Tinsukia Municipal Board. This court directs the Tinsukia Municipal Board to bring on record the basis on which the impugned notice dated 9/8/2023 was issued to the petitioner, and also indicating therein as to whether there has been any violation to the building plan or as well as the building permission so granted to the petitioner. List the matter again on
Got it. The 2 weeks.
28th of September 23.
Lord.
The affidavit be filed by 22nd of September 2023. An attempt shall be made to dispose of the petition on the record.
Lordship, SC Tinsukia Municipal Board name may be shown, Lordship. Today I have missed the case.
The registry shall show the name of Tinsukia Municipal Board in the court.
Obliged.
as directed by them, my lord, already I have given the parking slot nearby vicinity, my lord. That is also they have considered.
But Mr. Chetri, when you are given the permission to construct in a particular manner, unless you submit a revised plan, how can you do that?
No, my lord, that has been already accepted by them by filing a WS.
Forget about the place, that is not a part of it.
Yes.
Yes,
Yes, Mr. Lordship, I have received the instruction. I will be allowed to file an additional affidavit, ma'am, to bring the record, ma'am.
yes, what is your instruction?
What is the
What are you going to do?
Madam, hiring process is going on and acquiring process is going on. That will be, that will take some more time, my lord, for acquiring the land, my lord.
So you can't, and in this, during this period, you are to pay
During this
that.
process, we have, my lord, that is the, can we say, my lord, this
Now, what are you going to do from 2012 onwards to date?
2012, my lord, we have paid, my lord, for
You have to
2000
pay that, all the rent.
during the period of 2018 to 23, my lord, lease agreement for the payment of rental charges of the landowner has been processed by the DO Tezpur State. Agreement has been collected from the DO Tezpur for signature of
Okay.
all land. my
Ms.
lord.
A. Gayan appearing on behalf of the respondent
Yes, my lord.
submits that she would bring on record the affidavit, the instructions to receive within 7 days from today. List the matter again on 22nd of September 2023. The affidavit be filed by 29 2023.
Yes, my lord.
Yes,
Lordship, kindly pass over the matter for the date. It's the end of
Lordship,
the case out.
my lord, last occasion, some instruction was sought for, Lordship.
taken instruction is to find an aid to verify and input the document. Okay, yes, this is very relevant. FR dated in connection with the North Qatar has been submitted in the court of the chief.
29.
FR was filed. Yes, the court of the chief has passed on. When Yes, now, madam, what you need to do is go before the court. I dispose of this matter. This is what we have asked. Okay. Now, you see now, the next date is fixed out there before the Chief Judicial Magistrate Amin Gao on 29/9/2023. So I'll record it in the order. And you go, you file your protest petition. Isn't it? The petitioner herein has filed the instant writ petition seeking appropriate directions for carrying out an investigation through the Central Bureau of Investigation pertaining to Jalukbari PS case number 710/2014 and North Guwahati Police Station case number 45/2015. It reveals from the records that the final report in North Guwahati PS case number 45/2015 was submitted on 29/4/2019 before the court of the Chief Judicial Magistrate, before the learned court of the Kamrup Amin Gao. It further appears, now, this court, by an order dated 30/8/2023, has sought for instructions from the Superintendent of Police CID AHT Assam as regards what happened to the final report dated 29/4/2019 and whether the court had passed any order in that regard. Today, Mr. J. Hendig, representing the respondents, have placed an instructions issued by the Superintendent of Police CID AHT to the effect that the Chief Judicial Magistrate, Learned Student Kamrup Amin Gao, had passed an order dated 27/2023 for issuance of notice to the informant in GR case number 6051/2015, bracket, North Guwahati PS case number 45/2015, bracket close, in respect of final report number 17/2019, dated 29/4/2019. It has also been mentioned that the next date for appearance of the informant before the court of the learned court of the Chief Judicial Magistrate Kamrup Amin Gao is fixed on 29/9/2023. The said instructions is kept on record and marked with the letter X. So taking into account the above, this court, taking into account the above and the above, as well as the fact that the investigation have been duly completed and a report have been submitted, final report have been submitted before the court below. This court is of the opinion that the normal, the usual remedies available under the Code of Criminal Procedure 1973 can be availed by the petitioner before the Chief Judicial Magistrate Kamrup Amin Gao in the proceedings as mentioned herein above. Footstep. In that view of the matter, this court does not find that any order is required to be passed in the instant proceedings. Full stop. Be that as it may, the petitioner is given the liberty to file, to take necessary recourse to the appropriate provisions of law, if so agreed by the final report so submitted. With the above, the instant petition stands disposed. Oh, customs. Mr. Kyle, where is he? Have you passed any order on the 115?
Lordship, the hearing with the petitioner is fixed on 14th of September, your lordship. Thereafter, we'll pass the order.
They have not
passed yet, flying the vehicle since 2021. The moment your lordship asks them.
Okay, we will record that and we'll fix it after that immediately. 14th of September.
Yes.
We will have it on 20th of September. 20.
And it is Tuesday or Thursday, my lord. Morning, I made a mention to your lordship.
No, I will fix it if there is a new order passed. Otherwise, it makes okay. We'll have it on 21st. Miss Ardeka,
Yes.
appear the Standing Council GST, a Customs Department, submits that the hearing is scheduled as regards the case of the petitioner on 14th of September 2023. Taking into account the above, this court fixes the matter again on 21st of September 2023. On that date, the Learned Counsel for the Customs Department shall apprise this court as to whether any orders have been passed in relation to Section 115 of the Customs Act 1962 in respect to the vehicle of the petitioner.
Hasn't it, I have not received any date of notice for hearing.
Okay.
It is also mentioned herein that the petitioner, Mr. Jail, it is also relevant, however, it is however relevant to mention that as per the instructions received by Mr. J.L. Bhuya, the Learned Counsel for the petitioner, that the petitioner, however, have not received any notice pertaining to the hearing scheduled on 14/9/2020.
Okay.
Keeping that record clear, because otherwise later on. When is it? Yes.
On the last occasion, Lordship was pleased to call for a report from the PWD department regarding that illegal construction that was carried out by respondent number 4 and 5. Last order.
Which one? 4 and 5.
At a private respondent.
In the interview to be made if a report is being sought from the respondent number 3, that is the PWD department, as to whether the construction allegedly constructed by respondent. Oh, that one.
That one, that
Yes, madam.
hillside road, man. I appear for
Where's the PWD?
PW last occasion of beach totally appeared. But he is not well, man. He is down with viral fever. But
Well,
now the private respondents also.
I'm appearing for the respondent number, private respondent 4 and 5, my lord. I want to respond to the writ petition.
Very well, don't construct any further.
My lord, I have to take instruction on that.
Eh?
Whether we are still constructing or not constructing, I don't know, my
You
lord.
are appearing without knowing, and the basic reason is not to construct, and you don't know whether you are constructing.
It's not that may be fixed, my lord.
Whether you should not make a mention of this. You want to respond, then you don't construct. I've only asked as regards the
It's not that
PWD
may be fixed, my lord.
department. Taking into account that
Next week,
the
my lord.
PWD department is not represented today, list the matter on 15th of September 2023, on which date the council appearing on behalf of the PWD department shall apprise this court as regards as to the report which have been sought for by this court by the order dated 17/8/2023.
No problem. My presence may be recorded, my lord, because I filed wakalatnama yesterday, my lord.
Mr. Datta, this court doesn't record anybody.
My lord.
Did I record his name?
My lord.
You give your name.
Yes, yes, yes. I'm sorry.
ওখানে।
No, please, lord.
First day. মোশনও তাই বলেছে। মোশন नाही নিয়ে আসছিল। Listed for motion.
My lord, in the earlier occasions also saying in the orders column, my lord, listed, my lord, in
Ah.
other orders column listed.
Where is it? Earlier occasion this matter never came.
No, no, my
Then
lord,
why are you saying the earlier occasion?
this is not, my lord, this contempt is not, my lord. In other contempt petitions of my, which was filed by me.
Tell me what is the prayer?
My lord, due to the violation of the honorable court's order, my lord, the contempt petition has been
And the
filed. my lord.
exercise should be completed within 3 months from the
My-
date of receipt of the certified copy of the
My
order.
lord, I have submitted.
When
the,
did you
order.
submit?
My
To
lord, 23rd of
so Iman,
May
with due respect,
2023,
I
my lord.
understand. Where is the direction given?
My lord,
To be provided by the respondent number 1. Direction in the consult, the Deputy Commissioner Barpeta to examine the claim of the petitioner for grant of gratia of rupees 1 lakh in terms of the notice dated Iman and the petitioner representation dated Iman. In the event it is found the petitioner is entitled to the same, necessary sanctions for the payment of gratia to be provided by respondent number 1. Exercise be completed within a year. Now, who has not done what?
my lord, actually the verification is carried out by the deputy commissioner, my lord. That is why the order copy the petitioner has submitted to the deputy commissioner, my lord.
So,
And after that, the
are you saying that the deputy commissioner did not do it?
my lord, nothing has been communicated to the petitioner.
Is it mentioned in the order that it has to be communicated?
In view of the concern, my lord, the deputy commissioner is to examine the.
Why haven't you given it to the commissioner?
The petitioner has not submitted, my lord.
Why?
During the pendency, my lord, he will submit also.
The deputy commissioner will come and say, I made the verification matter. So,
The petitioner may be permitted, my lord, to submit the certified copy of this order to the.
we have not started till now.
Yeah.
Withdraw, file a fresh one. This is not the way you do it. You have given this. Inform him. Write to the deputy commissioner as well as the commissioner that look here, this is the order which has been passed. 3 months, 2 months has been over. And as such, where have you mentioned? The 3 months is over.
My lord, in the writ petition, I have.
The read petition is okay.
No, my lord, in the.
Have you mentioned this
Yes,
to the
sir.
person concerned? That you see the 3 months is over. Look here, if you don't do it, we are going to take action against you. Inform him. This is how you do it. They will say, I don't know. This is not going to get complied in this manner. You should know, just merely filing, it becomes a huge problem. How do you do it? What to do?
In the paragraph number 4, my lord, I have stated, my lord, in a statement, my lord, in the statement, I have stated, my lord, that, my lord, submission, the order, stipulated period of 3 months after the receipt of
The
this.
council withdraw, file properly. Or what do you want to do? List it for motion. Better. List the matter, taking into account that no notice has been issued, list the matter for registry is directed to list the matter for motion next week.
Right.
Some other judge may be more considerate. Yes.
Public.
Madam, you have not filed affidavit?
No, Lordship, I have not received instruction, Lord.
What is these matters?
Lordship, against the 2014 estate officer pass an order under public premises unauthorized occupancy act. Lordship, they challenged that in a miscellaneous eviction appeal, Lordship. That appeal was dismissed. They had filed a writ petition. Writ petition was also dismissed on 8/8/2023. Now they had filed this writ petition seeking compensation of 2 lakhs as the cost for their, they were shifted to another place and they have constructed a shop. So construction expenditure of that shop and also for giving them time till 31/12/23 to stay in that place. Now they are on status quo.
Where are they?
They are some
Yes,
businessmen.
status quo.
Yes.
What?
Because by the eviction notice, 2 days time was granted to vacate the premises.
So you have got enough time now.
Lordship, so we had stated that 2 days could not be.
How much day do you want?
Lordship, we had paid till 31st of December.
No. And those proceedings are almost over. What is this time? How much? 15 days. Only 15 days, nothing more than that. What is this? You have already got from more than that, almost a month from then.
15 days would be. That is may pay for 1 month's time, Lordship.
1 month. Vacate it. And forget over the compensation. What compensation you offer?
And they are already for 8 years they had run that shop and now they are seeking
Tell
compensation.
me under what provision you are entitled to compensation?
They had allotted that to the different. Lordship, they had allotted the different location, Lordship. We had shifted, thereafter we had constructed our shop.
Oh, yes.
Lordship, thereafter they said that the alternate plot which was allotted to us, that is also required for development activity. That was during the pendency of the retreat.
They have given, you are railway.
Railway lottery.
They were in possession of some premises
Yes.
where they had made some construction.
Lottery.
You evicted them.
Lottery.
Have you evicted them or not?
We had given the notice lottery.
Have you evicted them or not at
Yes,
any point
lottery.
earlier?
Yes.
Thereupon what happened?
Then we, although we disputed that that is passed by the estate officer on 2015, that is another plot of land were allotted to them to construct and construct their shop there. We, the officials are disputing that estate officer has no power to issue that order, lordship. But those were considered in the previous writ petition and then it was dismissed, lordship.
So you allowed them to move to an alternate
Yes.
site.
That is also railway land. That is also our railway land.
And again, you are going to throw them out later on.
They now we are being
Lordship.
evicted from the alternate land.
Are you going to again throw them out?
Lordship,
Yes,
that
No, if you keep on doing it, first of all, what is your business to relocate them?
lordship, we disputed that order.
Which
That
order?
is order that shifting them to another plot by estate officer that annexed our lordship. We railway officials said that this is not in consonance with the other officials and estate officer
No,
has no
because the
power.
fortune does not arise. You can't give it. The fortune of allowing them in some other place does not arise. It has to be, that allotment has to be given by the government.
Got it.
How can you allot any land to them? Tell me.
No, not allotment, on lease only.
You are giving it on lease.
Yes,
On
lease only.
license.
On lease.
License.
Now what happened? After that lease, you made some constructions.
Lordship, the issue is such that, Lordship, earlier we were on a plot of land, they required it, we were evicted. Lordship. We preferred Mr. That was dismissed. Lordship. Thereafter we approached before this honorable court. In the meantime, by an order that letter dated 2015, while the appeal was pending before the session judge, they advised us to shift an alternate plot of land. Now, Lordship, while we approached this honorable court passed an order that we were directed to vacate our earlier land, and within 3 days, the authorities were directed to allow us to shift to the alternate plot of land. We shifted to the alternate plot of land, we constructed our shop there and we were running our business. Now, Lordship, subsequently, during the pendency of this writ petition, the respondent authorities came up with the detailed map that the alternate plot wherein we were relocated, that is also required for construction of officers' base. So now, Lordship,
So you are asking for the cost.
I am asking for the cost of which we had incurred for relocating to the alternate plot of land, and for time till 31st to vacate the new plot of land which was given.
How could this court adjudicate that amount?
Lordship, because Lordship, right from the appeal stage, Lordship, that was our ground, Lordship. Lordship, and
How can this court adjudicate what is the amount? That has to be on the basis of the cost.
At that time, license fee was also not accepted by us for that plot of land.
And
But
then
you allowed them to make construction on that, knowing very well on the basis of some orders being passed by your authorities.
we are disputing that. Then he.
They have made
no
some
right.
construction, and thereafter one fine morning you just throw them out.
That is in 2015. 8 years they run there, up there. 2015 that. From 2015 to 2023.
No, Lordship, that is from 2018. 2018, the interim order is passed by this court. There are
Anyways, let's have these three matters for final disposal on Tuesday. Final matter, list the 18th matter on Tuesday for final disposal.
still then the interim.
Ms. B. Sharma appearing on behalf of the petitioner submit that
Respondent.
on behalf of the respondent submit that the materials on record would suffice for the purpose of deciding the writ petition. You want to file an affidavit?
I want to file it.
You want to file? Okay. Then you very good.
Actually, authorities wants to file.
Okay.
affidavit, Lord.
Ms. Ms. B. Sharma appearing on behalf of the respondents submits that the affidavit could not be filed and as such seeks for an accommodation of 4 weeks for filing the affidavit. List the matter on 6th of November 2000, on 10th of November 2023. The affidavit be filed by 7th of November. Interim order passed earlier shall continue till then. You see, the government is helping you out. Why do you need? We may issue a rule. Huh? No.
Authorities wants to file affidavit.
Yes.
My lord, this matter will what to have come up in the stability column, my lord. In the orders column. Look, I have filed an application for vacating the stay order. That is the matter. So
Yes.
the time is not permitted.
I for what?
I have for vacation of the interim order.
What interim order has been passed? What is the interim order?
28/7/2023.
Oh, that one.
That one. That one. He also
Mr.
made a
K.P.
request.
Pathak was appearing.
Made a request because he is also not out of station. So, Miller, kindly teach for on Wednesday next on 13th. I have no difficulty, Miller. He made a request. On Friday, Miller on Wednesday, Miller.
He wants that your petition should be allowed,
Yes.
isn't it?
There are some actual disputes. The resolution will be set aside, Miller. A direction may be given to Deputy Commissioner to hold the meeting within a specific period of time. That's Wednesday. There are lots of decisions in this manner. Miller.
I know that. Okay, next Tuesday. Matter has been heard at length. List the matter at the top of the list on 12th for final disposal.
Obliged.
Interim may be continued.
Huh?
Interim is there, that may be.
Nothing is going to happen.
Obliged. লিখিত